got it under control?
Yeah.
Yeesh. All right. Good afternoon, everyone. For those of you who were here late last night, it hasn't been all that long since I've seen you, but we have several calendars for today, but we have from yesterday a plea that I said we'd start with, which is Mr. Foster and Ms. Gardner. We've got Mr. Gordon on. Good afternoon, Mr. Gordon.
Good afternoon, Your Honor. I just received the correct link and I just sent it to my client, Ms. Gardner. So hopefully she'll be joining on the platform shortly.
Excellent.
But I just received the correct one, the updated link.
Okay. I appreciate that. I think I see her. So if she can turn her camera on. And then Mr. Foster was going to appear virtually.
He's in a waiting room. You see him?
So we don't have waiting rooms.
Oh, I mean, he's not waiting to get in. So maybe they weren't letting him in. I don't know. I mean,
There's not all you have to do is click the link and you're in. It's that friendly and open. Oh, someone is Zoom user. Is that, maybe that's what it was. Okay. Let me see if I can find that. All right, there's Mr. Foster. And then Ms. Gardner, can you turn your camera on? She did. Excellent. All right, I think we've got everyone we need. Ms. Davis, how's your foot?
it's better, Judge.
Okay. Can you hop on it or it's not that good?
Well, I haven't tried to hop on.
Okay, don't do that in here. Are you ready to, no, this is Ms. Clark's case, I think. Ms. Clark is here, great.
Did I put the podium seat?
Wherever you want to be, I just need to get a camera on you so Mr. Foster can see and hear you. So if you're going to be there, you should be in the middle so you've got the microphone.
Your Honor, can you give me Mr. Foster either his case number or his first name so I can pull his history?
You bet. He is co-defendant in this case, and the case number is 25SC 000-587. And it's Roderick Foster, also known as Zoom user, and he is co-defendant with Shelby Gardner.
Okay, thank you.
You bet. All right, and there is Ms. Rios and Ms. Clark. You're going to be right there. That's fine too.
Do you want me to move up to the witness box?
I want you to be where you're comfortable. So if you're going to stay there, you can stay right there. What do you want to do?
I'm fine.
You're good? All right. You're on the screen. Ms. Rivers, good afternoon. Are you able to hear us?
Good afternoon. Yes, I am. I'm ready.
Great. Then let's get on the record. This is, as I mentioned, 25SC 000-587, State versus Foster and State versus Gardner, both of whom were here for many hours yesterday. I appreciate your patience. Mr. Foster is represented by Ms. Rios, who is here in court. Ms. Gardner is represented by Mr. Gordon, who is appearing virtually. And before we start the plea, Mr. Foster, I need you to let me know that you're comfortable appearing virtually and not here in open court.
Yes, sir.
Okay, good. Keep your camera on. Ms. Gardner, same question for you. Are you okay appearing virtually from somewhere near San Francisco?
Yes, I am. This is the background. But yes.
I figured it was. And you know, if you've got any questions, you just need to let me know. And if you need to speak privately with Mr. Gordon, I can put you guys in a breakout room, okay?
Okay.
And Mr. Foster, same with you. If you've got questions, let me know. And if you need to speak privately with Ms. Rios, we'll send her into the jury room. She'll log in. You guys can have a private conversation, okay? All right. The way this is going to play out is that Ms. Clark is going to put you both under oath, and then she will ask you all the same questions, and she'll let the court reporter know. She'll start with Mr. Foster. So the question will be, do you understand that you have the right to an attorney? Something like that. She'll say, Mr. Foster, and you answer, and then she will ask you, Ms. Gardner. She won't repeat the question. She'll just ask that same question. She'll just ask you by saying, Ms. Gardner, okay?
Gotcha.
All right, Ms. Gardner, you need to leave your microphone on so that we can hear you. All right, are you on like a horse?
No, I was sitting on the bed.
Okay, because it's like, it's going up and down like you were riding near San Francisco. But all right, maybe it's the phone that's bouncing. Well, we'll see if we can make this work. Ms. Clark, when you're ready.
Yes, Your Honor. Before we start, I wanted to let you know that the cruelty to children in the first degree, the state will be amending that charge to cruelty to children in the third degree under 16570D.
16570D Delta. Okay.
Please raise your right hands. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
All right, and in the future, Ms. Clark's going to say Mr. Foster
Oh.
and then Ms. Gardner so that the court reporter can take down each person's answer. You're good. You both said yes. You can put your hands down and we'll go forward.
Okay, got it. Please state and spell your correct legal name, Mr. Foster.
Roderick Foster, RODERICKFOSTER.
Miss Garner.
Shelby Gardner, SHELBYGARDNER.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol? Mr. Foster.
No,
Miss Garner.
No.
Is there a medication that you normally take that you have not taken or been given today? Mr. Foster.
no,
No.
Miss Garner.
No.
How old are you? Mr. Foster.
35,
Miss Garner.
33.
What's the highest level of education or the last grade you completed? Mr. Foster.
engineering degree in the Brown University.
Miss Garner.
Bachelor's in psychology.
Are you able to read, write, and understand the English language? Mr. Foster.
Yes,
Miss Garner.
Yes.
Do you understand that you've been charged with the following offenses? And the state will be reducing, as previously stated, each count, cruelty to children in the first degree to cruelty to children in the third degree. So the charges are count 1, cruelty to children in the third degree, count 2, cruelty to children in the third degree, and count 3, cruelty to children in the third degree, sorry. Mr. Foster, do you understand that those are the charges the state is reducing the case to? I didn't hear you.
yes,
Okay. Ms. Garner,
Yes.
do you understand that you have the right to plead either guilty or not guilty to these charges? Mr. Foster.
yes,
Ms. Garner,
Yes.
do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial? Mr. Foster.
yes,
He said yes.
Okay. Ms. Garner,
Yes.
have you had the opportunity to review the indictment with your attorney? Mr. Foster.
yes,
Ms. Garner.
Yes.
And did you understand the indictment as explained to you by your attorney? Mr. Foster.
yes,
Ms. Garner.
Yes.
And did you review your waiver of rights with your attorney?
yes,
Mr. Foster. Ms. Garner.
Yes.
And is it your decision to waive your rights today? Mr. Foster.
yes,
Ms. Garner.
Yes.
Have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the facts and circumstances relating to these charges? Mr. Foster? Ms. Garner?
Yes.
Are you satisfied with your lawyer's services? Mr. Foster?
Yes.
Ms. Garner?
Yes.
Attorney Gordon, do you waive a formal reading of the indictment for purposes of the plea for Shelby Gardner?
Yes.
And Attorney Rios, do you waive a formal reading of the indictment for purposes of Mr. Foster?
Yes.
I did it backwards, sorry.
That's all right. You were clear on the record.
Do you waive any defects in the indictment for purposes of this plea, Ms. Rios?
Yes.
Mr. Gordon, do you waive any defects in the indictment for purposes of this plea?
Yes.
Do you understand that what you're entering is called a negotiated plea of guilty, to which the state is recommending the following to the court? Count one, cruelty to children in the third degree. The state's recommendation is 12 months probation. The special conditions of probation are set forth below, which are a successful completion of the Family First program requirements, including the mandated 8 sessions. Defendant will have only nonviolent contact with the victim child in this case. And for count 2, the sentence recommendation is the same, to run concurrent with count 1. And for count 3, no, excuse me, to run consecutive. Count 2 runs consecutive with count 1, and count 3 runs consecutive to count 2. Mr. Foster, do you understand that? The terms of the negotiation?
Right.
Okay.
Yeah.
Ms. Garner?
Yes.
So that I understand, it's a 36-month probated sentence with 2 special conditions: complete family first and no violent contact with Parker.
Right, Your Honor, and also too, upon their successful completion of the first family program, they are able to terminate their probation.
Okay?
Make sure that. Do you understand that the court is not required to accept the state's recommended sentence?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes.
Make sure you ask each defendant.
Okay, yes, I'm sorry, Your Honor. Do you understand that the court is not required to accept the state's recommended sentence? Mr. Foster?
Yes.
Ms. Garner?
Yes.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge? Mr. Foster?
Yes.
Ms. Garner?
Yes.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to demand a jury trial?
Yes.
Mr. Foster? Ms. Garner?
Yes.
Are you currently on probation or parole, Mr. Foster?
No.
Ms. Garner?
No.
Do you understand that if you're on probation, you must follow all the special conditions of your probation? Mr. Foster?
Yes.
Ms. Garner?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence? The special condition being you must complete the Family First program. Mr. Foster?
Yes.
Ms. Garner,
Yes.
do you understand that you are not allowed to possess or use a firearm while on probation? Mr. Foster,
Yes.
Ms. Garner,
Yes.
are you a United States citizen? Mr. Foster,
Yes.
Ms. Garner,
Yes.
do you understand that by entering a plea of guilty today, you're waiving all defenses, including any mental health defenses? Mr. Foster?
Yes.
Ms. Garner?
Yes.
Do you understand that by pleading guilty, you are giving up the following rights: the right to trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena witnesses on your behalf, the right to testify or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Mr. Foster, do you understand those rights? Ms. Garner,
Yes.
is it your decision to waive these rights, Mr. Foster, which means not to use them and to enter a guilty plea today?
Correct.
Ms. Garner,
Yes.
has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea? Mr. Foster? Ms. Garner,
No.
is it your decision to enter a guilty plea because you are in fact guilty? Mr. Foster? Ms. Garner?
Yes.
All right, excuse me. As to indictment number 25 SC 0000587, how do you plead to count one, cruelty to children in the third degree? Mr.
Yes.
Foster?
Guilty.
Ms. Garner?
Guilty.
For count two, cruelty to children in the third degree, how do you plead, Mr. Foster?
Guilty.
Ms. Garner?
Guilty.
And as to count three, cruelty to children in the third degree, how do you plead, Mr. Foster?
Guilty.
Ms. Garner?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you? Mr. Foster?
Yes.
Ms. Garner?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction? Mr. Foster?
Yes.
Ms. Garner?
Yes.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date? Mr. Foster?
Yes.
Ms. Garner?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition? Mr. Foster?
Yes.
Ms. Garner?
Yes.
Do you understand that for misdemeanor charges, you only have 12 months from today's date to file that petition? Mr. Foster?
Yes.
Ms. Garner?
Yes.
Your Honor, at this time, the state will provide a factual basis for the plea in this case. On July 15th, if the state would have took this case to trial, the state would have been able to prove beyond a reasonable doubt that on July 15th, 2023, Atlanta police received a call from Scottish Rite Hospital advising they had a 4-week-old baby boy in their care with an injury to his left femur. Investigator Lewis responded to Children's Healthcare of Atlanta. She met the social worker and the Fulton County DHS worker. The social worker for CHOA advised that the child was presented at the hospital and then transferred to Scottish Rite for further care. The social worker advised the parents of the child, Shelby Gardner and Roderick Foster, advised the child woke up fussing around 1 o'clock in the morning and was inconsolable. She advised the parents state they saw the left leg was swollen and it was sensitive to the touch, so they took their son to the hospital. Officers spoke to the parents while they were in the room with the child. Ms. Garner advised the baby woke up around 1 o'clock crying. She advised the baby was sleeping in his bassinet next to their bed. She advised they fed the baby 4 ounces of milk and he continued to cry. She advised Mr. Foster was holding the baby in his arms and standing in front of the open refrigerator doors in an attempt to cool the baby down due to it being very hot in the house. She advised when she removed the diaper to change the baby, she saw his leg was swollen. She also, this is when she decided to bring the child to the hospital. Both parents advised that they take shifts in caring for the baby and no one else lives in the home with them apart from the victim and their 17-month-old daughter, Taylor Foster, date of birth 2/1/2022. The officer spoke with the charge nurse and they were allowed to see the doctor's findings. The attending physician was Dr. Mark Arkovit, spelled Arkovitt. The findings were as follows: definite right classic metaphysical lesion of the distal tibia bucket handle with question distal left metaphyseal fracture. 2, redemonstrated acute displaced angulated left femoral shaft fracture. And 3, question metaphyseal fracture distal left radius and ulna, ULNA, attention of 2-week follow-up skeletal survey. Overall findings are highly suggestive to non-accidental trauma. After the CHOA made this determination, Your Honor, they did a testing to see if both Mr. Foster and Ms. Garner had like a rare bone disease. They did family history and they also checked the child. The child had no indication of that. In this case, Your Honor, based on the fact that the defendants, multiple people had access to the child, we believe that one of the hurdles would have been to actually prove beyond a reasonable doubt that either Mr. Foster and or Mr. Garner were the actual culprits of the injury. And so our recommendation is the Family First program.
Do you know from work that you've done on the case if there are any defects records indicating that the daughter, who made it through for many more months with that household, had similar types of injuries?
Yes, Your Honor. We did a research on the DHS file. Other than this incident, neither party had any incidents, and the child did not either.
Okay, thank you. So, Ms. Hardy, do you have any criminal history information for Mr. Foster?
Mr. Foster has 4 arrest cycles, arrests out of Georgia and Alabama. No felony convictions are reported on the GCIC.
And what's the most recent arrest?
This case that's on the calendar. Before that?
Nope, that's fine. So your records don't show anything. He actually has a new case here in Fulton County.
I'm sorry, let me look one more time. Okay, yes, I do see that one.
But between this most recent arrest, which would have been mid-25, and this case, which was back in 23, there are no entries?
No, nothing besides those 2.
Okay, thank you so much. And how about for Ms. Gardner?
Ms. Gardner only has this case.
All right, appreciate it. So, Ms. Rios, I'll start with you on behalf of Mr. Foster.
Yes, Your Honor. Mr. Foster.
Can you move the microphone down towards you? Thanks.
Mr. Foster is 35 years old. He works at Perfect Note as a chef. He has 5 children, ages 15, 16, 11, 9, 2, and 3. He's originally from Alabama, but he's lived here since 2019. He did complete his degree at DeVry, engineering degree at DeVry. I just want to state that the DFACS case was closed and the child is in their custody. They have no further.
That would be the 2-year-old?
Yes.
Okay.
And so there's been no further issues. The child is doing well. This seems to be an isolated incident. I'm not sure exactly what occurred, but it seems like it was if something did, it was an accident, and these are overall good parents.
And as far as you know, Parker can walk. That the left side got pretty beat up, but Parker doesn't have to just rely on his right side to
No, he's
interact with the world.
my understanding is he's a fully functional 2-year-old.
Okay. All right. Anything else?
No, Your Honor.
All right.
Oh, that you accept the plea as negotiated.
Okay. I figured that's sort of unspoken. Mr. Gordon, on behalf of Ms. Gardner.
Yes, Your Honor. Ms. Gardner is currently employed with Home Depot as a customer service representative. I believe she's been employed with Home Depot at least 3 years. She also matriculated from the University of West Georgia, where she obtained a bachelor's degree in psychology. In regards to the facts of the case, there are some concerns about the allegations and the opinions of the treating physicians in regards to how they came to the conclusion that this was a non-accidental accident there. So at this point, there's just some uncertainty as to actually what happened to Parker. However, my client, Mrs. Gardner, when she was contacted by the Department of Family and Children's Services, she cooperated with and was in compliance with everything that they asked her to complete. She was subsequently, as a result of her compliance, the family preservation case that DFACS had opened, they closed that. In addition, Your Honor, I can personally vouch for Shelby's character. I've known Shelby for many years, since she was very small. I was very close with her father, who was my mentor. And
Who was her father?
her father was Harry Gardner. He was the public defender for the city of Atlanta for more than 30 years. Her uncle, which is Harry Gardner's brother, was a senior solicitor with the city of Atlanta, with Raines Carter for numerous years. In regards to this program, I think she would have no issues with completing it. I would ask the court to follow the state's recommendation. In addition, it was also my understanding in regards to the negotiated plea that this would be under the diversion program, and once Mrs. Gardner successfully completed it, that the charges would be dismissed.
That's not what I heard Ms. Clark say. My understanding was that it was the same sentence for both defendants, which was the 36 months probation, so 3 misdemeanors, complete the Family First program, and if that program is successfully completed before 36 months is up, which I would be requiring anyway, probation could be ended early. So I don't know if you and Ms. Clark need to talk some more, or Ms. Clark is going to change her recommendation, but I heard her put on the record the same outcome for both Mr. Foster and Ms. Gardner.
Your Honor, if I may add, Mr. Gordon, if you refer to the emailed communication that I sent you Friday, August 1st, 2025, I basically go over the state's offer, and in the state's offer, I indicate the state will terminate the probation early. Defendant will need to complete all mandated requirements of the program, including the 8 sessions. There's no reference to dismissal.
Right, but when we had a conference, it was, let's see, what date was that?
So here's what I'm going to do. I don't need you guys to negotiate out in public like this. I'm going to wrap things up with Mr. Foster, and then it may be that Mr. Gordon, you want to give Ms. Clark. Is this your only case in here, Ms. Clark?
I have 3:30 motions here, Your Honor.
Okay, but that's a little bit later.
Okay.
I think I'm going to have Mr. Gordon, you give Ms. Clark a call. You guys can talk, and then we'll get back on the record to close things out with Ms. Gardner. I can't accept the plea if you guys don't have a meeting of the minds. In particular, because it's not just no, I want to advocate for less probation. What you've described is not a plea. Ms. Gardner shouldn't have even gone through this conversation, because if it's a diversionary situation, Ms. Gardner is admitted into a program, there's no plea. If she successfully completes it, the state drops the case. And that's not the process that we started a few minutes ago. So I don't want to derail it if you think that's what you've negotiated with Ms. Clark, but I also don't need to be in the middle of the back and forth. Okay?
Yes, Your Honor.
All right, Mr. Foster, I'm going to wrap things up with you. Do you have any questions about anything we've discussed?
Well, I was pretty much under the same impression that, like,
Mr. Foster, we can talk outside, but I've never said it was going to be diversion. I said it would be terminated after 36 months. Do we need to have a phone call?
Yeah.
I need to call you?
Yeah.
Okay.
All right. Mr. Gordon, last thing before we pause this, we'll get back on the record. We can wrap it up. I know Ms. Gardner has some obligations to pick up one or more of the kids we've heard about. Do we need to say, let's reconvene at time X when Ms. Gardner will be back? Or does she have the flexibility to hop back on just as soon as you and Ms. Clark are done talking about the case?
I can make arrangements to hop back on when they're done.
Okay, then why don't you can just go mute whatever you want to do, Ms. Gardner. Mr. Foster, you may need to drop off the call so you can speak with Ms. Rios. She's going to call you in a minute. Mr. Gordon, you may need to drop off as well so you can talk to Ms. Clark. Do you have a number to reach Ms. Clark that's not her desk phone? Or should we?
Yeah, he should have my cell number. On my email, it has my cell.
Okay. Do you have that, Mr. Gordon, so that you can give Ms. Clark a call?
Yes.
Great. I'm gonna have Ms. Clark go into our jury room. She'll be there waiting for your call. And we'll get right back to the Foster Gardner matter once Ms. Rios is back saying we're ready. And once Ms. Clark comes back saying, yep, Mr. Gordon and I have sorted this out, okay?
Okay.
All right, thank you all.
Mhm.
All right, let's get through today's calendar. First is a plea and arraignment calendar, position 1 and 2. Angelo Williams.
He's incarcerated. Yeah, he's online.
Oh, that's the gentleman in Dooley. All right, excellent, because I meant to say, let's do the person in GDC custody first. Mr. Williams, you are right here. Let me spotlight you there.
Please, Ms. Wood.
Ms. Wood, are you with us online?
I'm here, Judge. Can you hear me?
I can hear you. Let me add you to the screen as well. There you are. Are you representing Mr. Williams?
Yes, Judge. I will take both of his cases. If I may have a breakout session, I've spoken with Ms. Davis briefly. I don't know if it's going to resolve today, but I would sure like to try. So if I could have a breakout session whenever the court's ready for that.
Sure, I'll do that in just a few moments. I want to see how far we can get through calling the calendar. Mr. Williams, I've got a quick question for you. How much time do you have remaining on whatever case it is that has you in the Department of Corrections?
3 months. 3 months and a half.
Pardon me?
3 months and a half.
3.5 months?
Yes, ma'am.
Okay. Are you in on a probation revocation or what got you in?
My charges got me here, but it's probation revocation.
Okay. Got it. All right. What I'm going to do in a moment, Mr. Williams, is put you in a breakout room where you can speak privately with Ms. Wood. And she just wants to cover a couple things with you, and maybe we can wrap up your cases today. But if not, we'll at least start the process of moving towards trial or whatever is going to happen with your cases. So sit tight, and let me just see if Ms. Wood has any of these next few. Position 3 is Calvin Andrews. Ms. Wood, is that your?
That's Miss Rios, Judge.
You're right. Okay. You have both of Mr. Williams's because the older case has that lower number.
Yes, Judge.
All right. We will come back to position 3. Position 4 is Jairus Talbot. Hey, Mr. Talbot. I don't know if Ms. Cabrera is online. We got a lot of people online. Have you? Oh, no, because you need to hire a lawyer.
Last time I came, you all told me that a lawyer will reach out within a week or two, and I left multiple voicemails on, I guess, the DA's office voicemail, but haven't heard anything. I came up here the other week, last week, told me someone will reach out, still haven't heard anything. I don't really even know too much about this case.
Yeah, that's what everyone in this case seems to say. It's an interesting case. CSX. Yeah. So there's a lawyer listed who would be one who's appointed to represent you, but I also have this note here that said we're resetting it. Have we met before? Did you come the very first time?
Yes, you came.
And did you say, no, Judge, I'm gonna get my own lawyer. I don't want you appointing one.
You did, and made me write down my information, and he told me to give it about 2 weeks.
Okay.
And when I came here, I had that same conversation with counsel.
All right, I'm not doubting you. Ms. Nelson, do you have anything more in your notes? Because Mr. Talbot seems pretty clear that he wasn't planning on hiring a lawyer.
No, Judge, and I will reach out to Miss Euphemia and check with her.
Okay, so if you take a seat, we'll see. There's a lawyer who was appointed to represent you, but somewhere in the system, we thought that's not what you wanted. You were going to hire. Are you working?
I'm a realtor.
Okay. Realtors typically don't get appointed lawyers. Are you a successful realtor, or you wish you were a successful realtor?
Well, I'm successful, but I just started out 3 months ago.
What were you doing before you were a realtor?
Business, contract Home Depot and Lowe's.
And how did that business go?
Great.
Okay, so why would we be supplying a taxpayer-funded lawyer for you?
Because that business ended and I had shifted to something else, so.
Okay,
That's kind of what I did.
so times are tough right now, but when you were in the box truck business, things were good?
Yeah, I mean, it was, until it wasn't, I mean.
Okay.
I like that. Everything got messed up with that, especially with this case.
Okay.
Yeah, that cost a lot.
All right. Take a seat then, and we will see if we can get Ms. Cabrera on. I'm going to move you, Mr. Williams, into the breakout room now, and we'll see if you two can talk. Let's see what happens here. There's 1, and there's 2. Look at that. Ms. Rios, you have position 3, which is Calvin Andrews.
Not had contact with Mr. Andrews.
Neither have I. Ms. Davis, bench warrant?
Yes, Judge.
All right. We just talked about Mr. Talbot. We'll come back to that. Layla Faria, I apologize if I'm mispronouncing your last name. How do you say your last name? Faria, excellent. Good afternoon. Is 0 you or is 0 Ms. Wood?
Ms. Wood.
Ms. Wood, okay.
But it looks like it's conflict because it's Sydney Gibson. I believe she's with the conflict office.
Okay. Do you have a lawyer? Do you need a lawyer? As in, were you planning on hiring one, or do you do need a lawyer is the answer? Okay. You feel like you can afford an attorney?
At the moment.
Okay. This happens a lot when Sydney Gibson's name is listed, that then there's no one here. I'm not faulting her because I think she handles things pre-trial.
Yes.
Oh, this is this case. No, it's not. It's just one with 3 defendants. Oh, do you have, Ms. Wood, have one of these? Princeton Hines would be you guys?
Hold on 1 second.
It's three co-defendants.
Was 3. Trying to see if she would have one of the, who was from our office? Oh, yes, Princeton Hines is with our office, so she must have.
Mr. Lewis.
Yes. Oh, she does have Mr. Lewis. Ms. Wood did tell me about this case.
Okay. Yeah, he's online, so we'll get him in a minute. All right, so Ms. Faria, if you take a seat, we're gonna do a little exploring to see who your lawyer is, okay? How about Isaiah Gates?
No, yes, sir.
All right, Mr. Gates, and how about your lawyer? There he is.
Present, Your Honor.
Hey, Mr. Walls, how are you?
Good afternoon, Your Honor. I'm doing well. How about yourself?
I'm okay. Did we confirm Mr. Gates's situation? He's not going to come into the courtroom. Okay. All right. And that's a situation flowing from your team, Ms. Simpson. Okay. Mr. Walls, got to cover 2 things here. First, are you waiving arraignment for Mr. Gates?
Yes, Your Honor. I filed waiver about 12:30 today, and it was accepted in the Odyssey.
Great. It may not be visible yet for me, but that's good to know. And yep, it's in. So you've done a waiver. Mr. Gates, you are out on bond. Let me see what your bond order says. You're supposed to stay away from your co-defendants. That's pretty much it. Hopefully, that's not an issue for you. Did you get something in the mail today, Mr. Gates, telling you had court?
No, sir. I got something in the beginning of the week. I
didn't ask that. Well, did you get something in the mail? It may not have come today.
Yes, sir.
Okay. You live on Sonoy Road in Fairburn?
I do, but I need to change the address. I just moved recently with my mom a week ago, if not 2 weeks ago.
Okay. I need you to get your new address to Mr. Walls so he can do a change of address for you, okay?
All right.
Does Mr. Walls have all your other contact though? Cell phone, email?
He does.
All right, so he can keep you posted. Mr. Walls, by the entry of your waiver, I will get a scheduling order out, which gives the state a deadline to get you the discovery, gives you a deadline after that to file motions, et cetera, and we'll be off and running. There is one little wrinkle for Mr. Gates. Mr. Gates, I am being told that there is an active warrant for you, and you need to address that because it's going to sneak up on you otherwise. It's with probation. Are you on probation right now?
I am, sir, and I just came from doing a revocation for them for this charge.
When you say you just came, when was that?
That was, I believe, April. That was April.
Okay. Ms. Simpson, you have something more recent than that? Or maybe the warrant wasn't cleared from the system?
I believe it wasn't cleared from the system.
Okay. I'm glad you believe that. We need to make sure what's really going on. I just don't want you make a left turn where you shouldn't, and all of a sudden what would be a ticket is you're cuffed and you're going to jail.
Okay, yes, sir.
What jurisdiction are you on probation?
Gwinnett.
In Gwinnett? Okay. You say it was processed? Oh, that's when he said he had his hearing. So it may just be lingering in the system. Should he reach out to his probation officer? Okay. Mr. Gates, we can't solve this problem for you because it's a Gwinnett thing, but you or Mr. Walls should reach out to your probation officer saying, hey, I'm hearing there's still a warrant in there for me. Didn't we take care of this? And they need to clear it up, because if you did take care of it, that warrant needs to go away. But Gwinnett is the agency that has to make it go away. Okay?
All right.
All right. Mr. Walls, anything else on behalf of your client?
No, Your Honor.
All right, we'll be on the lookout for that scheduling order and we'll go from there. Oh, wait, let me make sure. Ms. Davis, anything from the state? Okay, that's it. You guys are free to go.
Thank you, Your Honor. Have a great weekend.
You too. Happy Friday.
Happy Friday.
Right. I just need his lawyer in here.
Ms. Wood is back out of the breakup room because there was a disconnect with but she filed a waiver number 6.
For number 6, we still need to talk.
Oh.
Hey, Mr. Lewis, can you turn your camera on, please?
Yes, sir, I'm here.
Good afternoon. I'm Judge McBurney. Were you maybe listening in while I was talking with Mr. Gates?
Yes, sir.
So you're in the same situation. You have an active probation warrant. Did you know that?
I was not aware of that, sir.
Have you been to court recently to deal with probation?
No, sir, I haven't heard anything from probation. I wasn't aware of that.
Did you know you were on probation?
Yeah, but I haven't heard from them since I got out of prison. I only went and seen them one time, and then I never heard from them again. I was never able to get in contact with my probation officer.
Well, there's your problem. Okay. What county are you being supervised in?
Cobb.
Okay. Well, they think you haven't been in touch with them. You think they haven't been in touch with you. They always win that argument. So there's a warrant for you, and you're going to want to clear that up. But let's focus on this case. Ms. Wood, this is Mr. Lewis. Looks like you filed a waiver of his arraignment.
Judge, I don't know if I actually went ahead and submitted it. I connected with him this morning, and so I am filing a waiver on his behalf, Judge. I do have contact information for him now, and yeah, I'll be looking forward to getting discovery on this case. Okay,
so you will do a waiver. That'll get your name in there instead of Princeton Hines. That'll get you discovery. That'll move the case along. Mr. Lewis, you can talk with Ms. Wood. So he's got your number, Ms. Wood, because it sounds like you connected this morning.
Yes, Judge.
All right, well, you guys should talk. Ms. Wood doesn't practice in Cobb County, but she has colleagues there or people she knows there. You're going to want to connect with probation. If you get pulled over for running a red light, you're going to end up going to jail, not for the red light, but because there's this warrant sitting out there, okay?
Yes, sir.
All right, hate to be the bringer of that bad news. I had nothing to do with it, but you certainly want to clear it up. Ms. Davis, anything for the state? No, Your Honor. All right, any other questions, Mr. Lewis?
No, ma'am. No, sir.
Okay, Ms. Wood, anything else?
No, Judge, thank you.
All right, you're free to go, Mr. Lewis. Stay focused on probation.
Yes, sir.
Ms. Wood, Ms. Rios told me there was some technical hiccup with Mr. Williams. Is he gone or is he back?
He's back, Judge. It looks like they're on a different device now.
Okay. Did you and he complete the discussion, or do I need to get you guys back in the breakout room?
I need another breakout room, Judge.
Okay. I'll do that in a minute. I want to press a little further through this calendar, and then we'll let you guys talk. All right, Mr. Talbot, Ms. Cabrera does represent you. I'm going to give you her phone number, and she's filed a waiver of arraignment on your behalf. So you need to reach out, just meaning she entered a plea of not guilty on your behalf. Probably what you want to do. Okay. I'm going to get you her phone number and her email address. You can reach out to her. Okay. And once you get that from Deputy Gordon, you should feel free to go. And so you know, in your case, 2 defendants have pled guilty. The third one, who is in state prison, is going to be pleading guilty as well. Doesn't mean you have to do anything. I'm just letting you know what's happened in the case. You're the last man standing. You and Ms. Cabrera will talk about it. Made me nervous standing there. All right. Charlie Daniels. Hey, Mr. Daniels. You're represented by Mr. Majeski? Any idea where he is?
Judge, he filed a waiver. The parties were excused.
Okay. Your lawyer filed a waiver of arraignment on your behalf, just meaning he entered a plea of not guilty. And my staff, that voice you just heard, that's Ms. Nelson, she told Mr. Majeski that you and he were excused. So he should have let you know that. It's good you showed up. I'm glad you're here. Yes.
Incarcerated, so my fiance passed, so I don't have his key number.
Okay.
I got my contact.
I'm going to give you his phone number in just a second.
And Judge, if you need some help, I can relay that information to him, and I can call Mr. Majeski if you need me to.
And this was?
This is Attorney Mike Barber. I apologize.
Oh, all right. Great.
Help the court.
There he is. All right. Thank you, Mr. Barber. Do you want to, why don't we do it this way? Why don't you give Deputy Gordon, Mr. Daniels, the best way to reach you, phone number, email address. He's going to give you a card to write it down. I'm going to pass that to Mr. Barber, who will get that to Mr. Majeski.
Is Deputy Daniels, he's in court or is he on Zoom? I assume he's in court.
Mr. Daniels is sitting in court, writing this stuff down right now.
Let me give him my phone. It's, if I can, Judge, or do you want me to give it through the chat?
No, you can give it to him in just a sec. He just needs another card to write that down on.
Yes, Judge.
We're going to run out of cards. Mr. Daniels, do you still live on Wyndham Way? Okay, so that's a good address. We'll be mailing things there, but Mr. Majeski will always get the info as well. Are you ready to write down a phone number? This phone number is for Mr. Barber. That's not your lawyer, but it's a friend and colleague of Mr. Majeski's. But that way you've got a number to call and he can give you more information about Mr. Majeski, okay? We're ready, Mr. Barber.
It's 404-445-8494, Your Honor.
Great. 8494?
That's correct.
Okay. And I'm going to send you a text, Mr. Barber, that is Mr. Daniels' phone number, if you will do your best to get that to Mr. Majeski.
Of course. I can absolutely do that.
Thank you for being the intermediary. All right, done. So Mr. Daniels, you're good to go. You've got info on Mr. Barber, not your lawyer, but friend of Mr. Majeski, and Mr. Majeski is about to get your phone number. All right, see you around. Tylea Woodson. Hi, Ms. Woodson. Pardon me? I'm okay. How are you? Good. Ms. Rios, your client?
Yes, Your Honor.
Have you all spoken?
Yes.
Great.
I filed a waiver, but we do need to address her ankle monitor.
Okay. Is this something Ms. Davis knows we're going to be talking about, or you want to talk about it anyway?
I filed filed a motion. I thought I included you in
This is
this.
a DPK judge.
Oh,
Okay, let's try.
Okay.
okay. I'm fine talking about it. I just need to make sure there's a prosecutor who is ready to talk about it as well. And sometimes that involves reaching out to the alleged victim in the case. But in terms of the arraignment part, you filed a waiver, so that'll get that moving forward. We can talk about bond once we figure out who the lawyer is handling the case for the state. Let me ask you, Ms. Woodson, a question, since I got you right there. Are you still at Commerce Drive, at an apartment? Okay, good. So we've got a good address for you. And then the one condition that you want to talk about is the ankle monitor condition, Ms. Rios?
Yes, Your Honor.
Okay. Which has been on now for 8 months, nine months. Pardon me?
245 days, is that?
Not that you're counting? Okay, is it one that the county is paying for?
Yes.
Okay, so it's free, but you got a big old box on your leg.
Yeah, and the problem is that
Well, I'm gonna let you talk about it. We just need to figure out who the lawyer is for the state, okay? Malik Lewis is who you're supposed to stay away from.
I'm under the impression from the last judge that it was just no violent.
Oh, you're right. It does say that. It says no further violent contact. What was the ankle monitor for?
I'm not sure. She literally just put it on me and told me that, like, I don't even have any conditions with the ankle monitor. I can go anywhere, do anything. I just have it on me.
Interesting. And you're still wearing it?
Yeah, it's on.
Okay. All right. But you're not enjoying it?
No, not at all.
Okay. I haven't seen a bond like this before. Okay. So this would be Ms. Willingham?
I'm texting her now.
Okay. All right. Ms. Woodson, if you'll take a seat, we will address this today. Because even if the prosecutor can't get here, she can certainly communicate to one of the prosecutors here to say, hey, here are my thoughts about it.
All
All
right.
right.
It was my fault. I emailed the wrong prosecutor. I let them know about
That's
the
okay. We'll see if we can work through this. And now into the case with so many defendants. Mr. Bradford? How do you pronounce your first name? Quadir Bradford. Good afternoon. How are you? All right. Do you have a lawyer?
Yeah.
Who is that?
I don't know.
Well, I thought you said her.
No, I
Oh, why did you think a lawyer would be here today?
was cool.
Okay, who told you a lawyer would be here today?
Judge,
Ms. Wood?
I'm going to interrupt. I'm sorry to interrupt. This is the gentleman who didn't have a first appearance and I stepped in, but Miss Rios has the co-defendant. So I did tell him I was hoping that there would be an appointed attorney for him there today. So
All right, which of the many defendants does your office represent?
Patterson.
Tyrone Patterson. Okay. So we need the conflict defender's office to go into overdrive because assuming people showed up, there are going to be a bunch of people here with no lawyer.
That's correct, Judge.
Okay. All right. Stay right there. So Ms. Rios, you have position 15. All right. So Mr. Bradford, let's get into this case. How did you know to be here today? Did you get something in the mail or that mystery voice we just heard told you to be here? Pardon?
Yeah, she told me yeah.
Okay. Do you still live at Braylorn Court in Stone Mountain? Okay. Did you get anything in the mail telling you to be here?
No, but I had booked. She told me to be here on the 8th to meet with
With a lawyer. Got it. And that was the right advice. And the hope was that there is a system that appoints lawyers when there are multiple defendants, because you can't have a lawyer from the same office as someone else in the case, because they need to be able to represent you independently of anyone else in the case. And for whatever reason, this case has 1 million defendants. So we need to get you a lawyer, and we will do that. But it's not going to happen right now. So you will get something in the mail telling you when you need to be back here. Ms. Wood, do you have additional contact information for Mr. Bradford that can be forwarded to whatever lawyer is appointed to represent him?
Yes, Judge, I've spoken to his family quite a bit.
Okay, excellent. Do you have a cell phone? Does it end in 6167? Yes? Okay, so it sounds like there may even be a phone number in the system that can get to that lawyer. So we'll work on figuring out who your lawyer is going to be. You may want to check in. If it's been a month and you haven't heard anything, you may want to call my office saying, what's going on? Okay? Anything else? Okay, well, I appreciate you being here when you said you'd be here. You're good to go. All right, same case, different defendant, Raheem Smith.
Hi, good afternoon.
Hey, Mr. Smith, how are you?
I'm fine, you?
I'm all right. Do you have a lawyer?
Yes.
Who's your lawyer?
Mr. Melnick, John Melnick.
John Melnick. Do you know where he is?
Told me you were honoring and Gwinnett. I'm today.
All right.
I've been from in Zoom today.
Okay, he may. He is a man of many demands. He may be exactly where he told you. Let me find you in the case, Mr. Smith. He's already filed an entry. It just didn't make it into the situation here, and he waived arraignment for you. This is all hitting the docket very recently. So you are good to go. Let me make sure I've got the right address for you. Baywood Lane,
Yes,
Riverdale. Okay. And Mr. Melnick knows how to reach you?
Yes, you are.
Okay. He's filed the right paperwork for you. So Raheem Smith, you're good to go.
Thank you.
You're welcome.
Yes, Judge, just so that you know, Mr. Melnick did get in touch with us, so he's good to go.
So you're doubly good to go. All right. See ya. Kamoy Francis.
Bench warrant, Judge.
How would this person know to be here? It's a direct indictment of Kamoy Francis. There's zero information. I can't tell you if Kamoy is male or female. There's no booking photo. And I don't see a grand jury warrant. So I think that would be the next step, would be to get a grand jury warrant rather than a bench warrant, because other than word of mouth, because there's so many defendants in this case, I don't see anything indicating that Kamoy knows that Kamoy Francis is in this case now.
I'll look into it. If it was directly indicted, we should have been on the warrant with that. It's not.
Should have. I know that's not on you, but that rarely happens these days, the grand jury warrants. I don't know why. And then it just sits out there. I say rarely. Let me put it the other way around. I often see this situation where a defendant is added and no one, I mean, you know the person was added, but that person doesn't know and there's no warrant for that person. This is not atypical. So what we'll do is I'll give you some time to figure out if you can do a grand jury warrant. Otherwise, I'll put this just go into judicial hold. This one defendant, not the whole case. But there's no point in leaving it open if there's not going to be a warrant that would cause someone to grab Kamoy Francis if that person encountered law enforcement. All right. Shanika Francis.
Good hearing, Your Honor.
Are you related to Kamoy Francis? How so?
That's my younger brother.
Your younger brother. Okay. Entirely up to you whether you want to let him know he's mixed up in this case now. He is not in trouble for not being here today. But the sooner he plugs in, the more he may be able to control how his entry goes, warrant versus not warrant. But you can talk with your lawyer about whether you even want to get in the middle of that. But it might help him out. Are you Ms. Brown Melchor?
Yes, Your Honor, and we were been filed on motions. This was a re-indictment, so we were pretty far along last time.
You were already in it?
Yes.
Okay, great. We have to reset it in the sense that they're new defendants. That'll be a very shallow hill for you to climb. It'll be steeper for the people who are new to it. Anything else you need to talk about? All right, Ms. It's not, it's Ms. Davis. So, Ms. Brown Melchor, you received a first batch of discovery. There may be new discovery explaining why they're new people. Were any charges added as to your client? New people.
I know there was some outstanding stuff that was still was working on the first go around that we haven't received yet, so maybe that's already been kind of gathered and might be shared this second go around.
Sure. Well, and certainly check with Ms. Davis. She's done an amazing job of picking up where Ms. Dillicard left off, but you know, there could be notes inside of notes that she hasn't seen, and so you can help her figure out where things were headed.
Thank you.
All right. And Ms. Francis, you're at the same address you were at before? Pardon me? Oh, I don't have it in front of you. If you haven't moved, then we're all good. Okay, that's it. Thank you. Yes, ma'am. Amaya Harrigan? Hey, how are you? All right. Did you have a lawyer before in this? You were in this case before.
I was appointed a lawyer, but I'm not sure if I moved and we haven't spoken.
Oh, you have Ms. Cabrera. Okay. Ms. Cabrera was in a trial for 7 weeks. Pardon me? She's not here. But that's why you haven't heard from her, because she was stuck next door for, you know who Cash Out is? Me neither. Yeah. She was in that case. Didn't go so well for Cash Out. So, that's your lawyer, and she's done a waiver for you. So she took care of the paperwork that needs to happen, meaning she entered a plea of not guilty on your behalf. So she'll get discovery. But if you are comfortable giving Deputy Gordon your contact information, I'll get it to Ms. Cabrera. She has it? Yes. Well, guess what? I'm going to give you hers. Do you have hers? Okay. What area code do you dial when you call her? Well, no one has an area code of 1. It's 3 digits. Is it in your phone? Look it up. Because if you're calling the wrong number, she's probably not going to call you back. That's fine. You're actually allowed to have your phone on in here. Just can't make noise. Well, we're waiting on that. How about Mr. Patterson? Hey, Mr. Patterson. Ms. Rios?
Yes, Your Honor. I represent Mr. Patterson. I was on this case before. I think I already filed another waiver.
You did a waiver for the new indictment?
I believe I did. I'm just double checking right now.
And has the state null-prossed the old one? Has that gone and out of our hair?
Yes, it's closed.
Yes, it was. Okay, great. So do you need Mr. Patterson for anything else, Ms. Rios?
No, Your Honor, I have the contact information for him.
Okay. Mr. Patterson, Ms. Rios will be in touch with you when something more is happening with your case, all right? Any questions about anything? Appreciate you being here.
I did file a waiver.
All right. So we actually have lawyers for a bunch of folks. What'd you find? If I just give it to you again?
Yeah.
Okay. And do keep trying her. And we will connect you to someday.
And then is the next court date set now?
We don't know the next court date. What'll happen is your lawyer will get discovery And then she will meet with you to say, here's what we got. This is how you're connected to the case. And you and she will talk about, well, what's a good defense? You might have an alibi. You were in Honolulu when this happened. Or I'm the victim, not this person. You guys will talk about that and we'll take it from there. Yeah, sometimes it's Ms. Damour, Damour. I don't have the full story behind which name you're supposed to use. I go with Cabrera and she says hello. I mean, she doesn't answer my calls either, but. All right. Thank you, sir.
Your Honor, of course, whatever order you want to go in everything, but my client is ready to go finish with the plea so he can go to work.
Okay. This is Foster and Gardner?
Yes.
We'll do that. I want to get Ms. Wood in the breakout room with the gentleman in the state custody and make sure. Ms. Harrigan, she's gone. You're all set? No, that's okay. You got the number. You're good to go? So that just left. Did she say it was her brother? Kamoi's a guy. I think she said that's my brother. Okay. All right. So you'll figure out what you're going to do on that front. Let's get Mr. Williams. There he is. Mr. Williams, I'm going to put you in a breakout room, okay? You can finish your, hopefully Dooley's iPad works better than the other connection. And you and Ms. Wood are going to talk a little bit more about your two cases, okay? All right, they're in. So we can get back on with Foster and Gardner. Ms. Clark, did you and Mr. Gordon sort things out?
I do believe so, Your Honor.
Okay, well, we'll find out in just a second. Let me load up the screen again. There's Mr. Gordon. There's Mr. Foster.
Your Honor, my client, she had to pick up Taylor, so it might be maybe around 5 more minutes once she gets to the location, and then she'll be able to join back on the platform.
Okay, well, we'll finish with Mr. Foster now. I don't mind. We did 99% of the situation, so I'll spotlight you, Mr. Gordon, and then just let someone know when Ms. Gardner's on, and we'll just wrap up Mr. Foster right now, okay?
Yes, Your Honor.
All right, Ms. Rivers, are you okay getting back on the record in the Foster and Gardner case?
Yes, I am.
All right, we are back on the record as to Mr. Foster only at this point. He is back online. His lawyer, Ms. Rios, is on with us, and we have Ms. Clark, the prosecutor, back. Mr. Foster, when we paused, I think you were in a different place. You look like you're like on an airplane or in a bus or something now. Can you say that again?
I was headed to work.
So you're like on a MARTA bus?
Yes, I'm on the MARTA bus.
Well, look at you riding MARTA. Don't hit your head. All right. Mr. Foster, when we paused, you were expressing some confusion about, wait, I thought I was getting diversion versus probation. Ms. Rios, did you and Mr. Foster have a chance to speak?
Yes, Your Honor.
Okay. And does he now understand the situation?
Yes, Your Honor.
Mr. Foster, are you ready to go forward?
Sure.
Okay. Mr. Foster, I find there's a factual basis for your plea and that your plea was knowing and voluntary. You understand that this plea only resolves the case involving Parker. It's nothing to do with the new charges you have. Okay. I'm going to follow the joint recommendation and sentence you to 12 months as to each of the 3 reduced counts. The state has the authority to reduce your charges to misdemeanors, and they've done that. So that's 36 months probation. The special condition of probation is that you complete the Family First program, which is not just one class, it's a variety of obligations. If you successfully complete Families First, then you should let Ms. Rios know, and she can petition to have your probation terminated early. And if everything has been going well, you haven't been arrested for anything else, I'm happy doing that. Does that make sense?
Yes, sir.
Any questions?
Yes, sir.
Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Clark, can we sign for you?
Yes, Your Honor.
And Mr. Foster, is it okay if we sign the indictment indicating your plea to the 3 misdemeanors?
Yes, sir.
All right. Where is this place where you are a chef?
Perfect note.
Yeah, where's Perfect Note?
It's in Maryland, off Windy Hills. It's right beside the Brain Stand.
Got it. How long have you been a chef there?
For 2 years.
Okay. Well, good luck with things. Ms. Rios will let you know how you report to misdemeanor probation, okay? All right. Bye-bye. All right. Ms. Wood will let us know when she's out of that room. Let's get to our other calendar for this afternoon. Inquiry and motions. Position 1 is Kayla Brown. Ms. Brown, are you here? Hey, Ms. Brown, can you come on up to the podium, please? Mr. Barber.
And that's for me, Your Honor. I'm here as well.
It is you. That's right. So let's get.
It is I.
That's right. So we'll get all the pieces we need on the screen here. Sorry, the podium's right up there where there's the Kleenex box. All right, Ms. Brown, I had you come in today because Mr. Barber has filed a motion to withdraw as your attorney. And before I grant that motion, I needed to make sure that you understood that that was he was doing. And if he says the reason why is X, that you have a chance to say, yep, that's the right reason, or no, I disagree, and I want him to stay as my lawyer. He filed an entry on your behalf. And so he is your lawyer until I relieve him from those responsibilities. But if the relationship isn't working, or if you promised to pay him and you didn't pay him, or whatever it may be, then I can release him from that obligation. This is a complicated case. It's going to take a long time. And so I'm reluctant to let someone go from the case. But if it's the right thing to do, I will certainly do that. So I'm going to start with Mr. Barber and have him share with me what he wants to. He may not necessarily say, hey, here's some things I discussed with Ms. Brown, because what you two talk about is privileged. And he cannot waive that privilege. You can. And so you may say, well, let me tell you something I told Mr. Barber. Just know that once you say that, that's sort of out in the open. Mr. Wooten is here as the prosecutor. He doesn't really have a dog in the fight, so I'm not going to be asking him, what do you think should happen? But he, of course, is entitled to be here because we're talking about your case. All right? Mr. Barber.
Yes, Judge. Thank you. Ms. Brown hired us quite some time ago, and we entered into the case on a basis of what our understanding was with her. After having been in the case for a while, and discussing with DA Wooten, it has expanded past the scope of our original contract, which that's okay. However, we have not been paid in the last 4 months. So we sent a notice to Ms. Brown pursuant to statute, and we still haven't been paid, and we are before your honor with our motion to withdraw.
And the nature of the financial arrangements were not, here's X dollars as the retainer, do my case. It was, maybe there was an upfront payment, but there were also to be payments over time.
That is correct. Under the original contract, once it exceeded the scope, we told her she needed a new contract. which is in our contract, by the way. If the scope is exceeded, not in so many details, but basically if the scope is exceeded, a new contract will be required. We notified her of that also in the letter, and it still has not been signed. But under any event, under the original contract, she has also quit paying.
Okay, got it. So Ms. Brown, I don't need more details than that unless you want to share them, but it sounds like it's
that's not true, and he know that's not true.
okay.
So the original agreement, I pay him. I'm out of thousands of dollars. He's done nothing. For one, I can never get in direct communication with him. He told me that the price of my contract will only change if my case turned federal. He knew that I had a superseding indictment from the beginning. I had to provide him information of my funds, and he kept changing the amounts that he wanted. I guess he saw that I had access to X amount of dollars. I'm not paying you $100,000 just because I got it. And you haven't even did nothing with the thousands that I paid. I'm not paying you that. The monthly, it was on auto pay. It came out every month. I've never missed a payment. His office stopped charging my card. I called them like, why haven't y'all charged it? Oh, he said he's not accepting any more of your monthly payments. He wants the $90,000. I told my mama, I said, he haven't even did nothing for the thousands that I'm paying him. I'm not giving him nothing else.
Okay.
I hired somebody else. That's what I meant.
All right. Importantly, I'm not going to step between the two of you in your business dispute about whether Mr. Barber has or hasn't done work for you, or if he's charged too much, or if the past 4 months, it's not that you haven't been willing to pay, they just aren't charging your card.
I've never missed a payment. A payment has never been late. It's been on auto pay.
Okay.
So
well, what I heard you
stopped paying, that's not true.
What I heard you say at the end is, you know what, enough is enough. I'm gonna hire someone else.
Right.
Is that your plan?
Yes.
Okay. So if I release Mr. Barber from representation, you don't have an objection to that. You just want some time to be able to get a different lawyer.
Correct.
Have you already begun that process?
I've spoke to people, but they've been saying like with him on my case and with the trial date being so soon, they don't know. They saying they have to file certain things to get the trial date pushed back, and they can't do that with him on the case.
I'm going to look up the trial date. I didn't know we had a trial date yet, but I don't run that kind of stuff. But certainly, no lawyer is going to say, sure, I'll do X, Y, and Z when you have a counsel of record in the system. But we can fix that, and it sounds like we will. But if I look at your case, there is a trial date. We'll talk a little bit about how realistic that is. I mean, it's not at all now if you're switching lawyers. We'd have to switch that around. But we also only, I thought, fairly recently added your mother as a defendant, and I don't know where discovery is in terms of everyone being ready for that. But most importantly and fundamentally, hold on, Mr. Barber, you have the right to any lawyer you want, provided you can afford that lawyer. And if you can't, we'll appoint one for you. And I'm hearing you say, in no uncertain terms, goodbye, Mr. Barber, and I'm gonna bring someone else in.
Yeah, I've paid thousands of dollars and nothing's been done. It's certain motions that have been supposed to been filed months ago in January, like health related motions. I need to go out of state to get some health related stuff done. I think paralegal said that they were going to file something. I never heard anything back. I was checking in like for 2 months, never heard anything back. I started checking online to see if any motions had been filed. Nothing.
Okay. But you are financially in a position to bring another lawyer on board.
Yeah.
Okay. Mr. Barber, I'm going to repeat one thing that I said, which is I am not interested in getting between the two of you and your representation disagreement. But I am hearing Ms. Brown say that she does not object to you withdrawing. So I'll certainly make that happen. I'm not preventing you from saying anything else if there's anything more you want to say.
In due candor to the court judge, I would like to point out that the superseding indictment did not come about until her mother was placed onto the case. So there's no way I knew. But that gets into what you said you didn't want to hear about.
Right, it does. I don't. I'm going to let you guys duke that out. That's what parking lots are for. But I don't want to get in the middle of that one. So, Mr. Barber, if you will get me a proposed order, and if it's attached to your motion, just tell me that. But otherwise, if you will send to Ms. Nelson a proposed order, I will sign it that allows you and your firm to withdraw. and then Ms. Brown can pivot and bring someone else on board.
Yes, Your Honor. Well, I will do that.
Thank you. Ms. Brown, I need to get a good sense from you about how quickly you can bring a lawyer on board, which is different from how quickly that lawyer needs to be ready. We'll have to have a conversation, Mr. Wooten and you and I and lawyer X, so you can reassure that lawyer that that person doesn't need to panic about that trial date.
Okay, so I have questions.
Hold on one second. Mr. Barber, you're free to go if you want. You're welcome to stay on, but
Thank you.
I think we've addressed your part of this discussion.
I didn't want to leave without permission. I appreciate it. Thank you.
See you around. Oh, and thank you for helping get word to Mr. Majeski.
Of course, Judge. Thank you.
I interrupted you. I'm sorry.
Yes, so I had been talking to one maybe a couple of months ago, and I explained to his paralegal that I had been speaking to one or whatever. This was before he tried to come out with the absurd number or whatever. It was just, I felt like nothing was being done in my case.
Okay.
And they were telling me that something had to be filed through the courts, and they had to file something asking for a certain amount of time because I had a trial date on.
This other lawyer was saying
Yeah,
that?
so
Okay.
a lot of the lawyers that I spoke to, they've been like scared to take on my case because the trial date is so soon.
Okay.
And my case is so complex.
I want to give you more assurances on that, but I want to hear from Mr. Wooten. Mr. Wooten, right now, we've got a motions hearing date that is a month and a day away, a final plea date that's about a month after, and then the case would be on our October trial calendar. That seems not particularly realistic because Ms. Brown's getting a new lawyer. How are we doing with discovery and your interactions with the other two lawyers?
So discovery's been served, excuse me, on Ms. Brown's now former counsel. All of it's, they've got everything. I'm not sure how that transfer would need to take place.
It's all digital.
It's all digital.
So it should be doable.
Yes.
Okay.
And
I'll put that in the order that Mr. Barber is under obligation to, as seamlessly and promptly as possible, when there's an entry of appearance. So when your new lawyer files something saying, hey, it's me, then Mr. Barber is obliged. I mean, it's his professional obligation anyway. We need to make that happen.
Same situation for Mr. Jones and his attorney. All discovery has been turned over. As it relates to Ms. Jones, I've had some email communication with her attorney. I've requested a hard drive be dropped off. It's ready to be turned over.
Remind me who that person is.
That's Chris Campbell.
He just waved his hand.
I'm here on that, Judge. I have the jump drive ready.
Fantastic. Look at this. We're gonna accomplish a bunch of things here. All right. So one of the other defendants has everything and has been chewing on it for a while. You guys will close the loop today for the third defendant.
Yes.
Okay. What are we looking like from the defense side in terms of the practicality of these deadlines, since we have all the lawyers here?
Yes, Your Honor. Nicole Holman from Mr. Jones. We were going to ask for a continuance of the motions deadline. We do have all the discovery. We have had it, but there's a lot.
I've heard, and it grew.
Yes.
The addition of a defendant also included the addition of discovery.
A lot.
Okay. All right. So you were so the motions hearing is a month from now. I don't know if there was a deadline I know there is in a scheduling order. There was some deadline for filing motions.
Right. The deadline is the 18th, so not this Monday, the following Monday. So we would be requesting at least 30 days.
Okay. Because of the volume of the discovery? Okay. And you have no discovery, so I'm guessing by the 18th of August, you might not be ready either.
No.
Okay. And Kayla Brown has no lawyer right now, and so there's no one to be working on those things. How about this? How much, you guys can take a seat. You should be comfortable telling the lawyer or lawyers you're talking to that these deadlines are going to be moved. I can't give you a specific date for when trial will be, but it will not be in the middle of October.
Okay, and I have one more question. With my prior attorney, I had spoke to him. I spoke to somebody in his office because I could never get direct contact with him. I give birth in like 10 weeks or whatever. I asked him, could he do something where I'm like virtual court, whatever. Nothing has been done on my case. I just been paying money. So I don't know what I do in the meantime as far as that. Because I think I'm supposed to be back in court in like 4 weeks or something like that.
So two things. One, your medical situation, that sounds very clinical, but you giving birth would always take priority over court. So if there was some court event scheduled and the word is, hey, that's my due date, then court has to move. And court doesn't happen the day after your due date either. We would accommodate that. What it doesn't mean though is, hey, I need to be the exclusive care provider for my child for the first 3 years of, is it, do you know, boy or girl?
A boy.
For my son's life. Fairly soon after, assuming you are physically well enough, you'd need to be in a position to plug back in. Now, your lawyer is able to be doing things left and right while you're focused on what's important.
Okay.
So we might have to, I'll say, tap the brakes on the case because you're going to focus on giving birth. But we wouldn't say, full stop, we'll see everyone in 6 months, absent some bad medical situation, which everyone hopes doesn't happen. So if you're healthy, baby's healthy, then we get back to it pretty quickly.
Okay.
Your lawyer's job will be to let Mr. Wooten know about that. And then ultimately the lawyers will come together and say, Judge, we were all set to do something here, but we need to move it to here because of this happy situation.
Okay.
First kid?
No, third.
Third kid. Okay. I don't know that there's going to be a calendar collision because we're going to need to move things because of the new lawyer coming on and because of the size of discovery. And while Mr. Campbell's not a new lawyer on the case, if he didn't get discovery till today, he's effectively a new lawyer on the case because he's got to look through all that. And it's a bit. So, Mr. Wooten, you'll get the hard drive or jump drive from Mr. Campbell and figure out how to populate it, get it back to him. And you, Ms. Brown, now need to answer my question, which is, how soon do you think you can have a lawyer on the case?
I'm going to call back the lawyer that I've been in touch with on Monday morning. I've been like in contact. I've just been waiting for him to get off.
Yep.
Because when I was arrested in December, my mom said when I got out, we were going to get a new lawyer. But we tried to stick it out with him. He's done nothing.
Well, it didn't work out. And I hear that. So I think what I'm going to do is set a court date for you that's a couple weeks out. And if you have a lawyer who's filed an entry of appearance, you don't have to come back to court.
Okay.
But if you don't have a lawyer who's filed an entry of appearance, you need to be back in person. It's not a Zoom thing. And we're going to need to talk about when is this going to happen.
Okay.
Okay. And I think that's it. Mr. Wooten, anything else from the state?
2 quick things, Judge. Just first, I believe that there are some victims on the Zoom.
Mhm.
I'm not sure if, full candor, I'm not sure if what's before the court today gives them the right to be heard, but I would ask that if they would like to be heard, that the court allow them to be heard as it relates to scheduling. They've been waiting years for this case to proceed. So I would ask that, number one. And then number two, there was another issue as it related to the bond on the cases. So it's a little bit technical and essentially the first indictment as it relates to Ms. Brown.
So before you go any further with that, Kayla Brown now has no lawyer. And so I don't want to get into anything where she ought to have a voice speaking on her behalf. Unless it's, oh my gosh, what's going on with bond right now is like more fraud is being committed and you need to do something about it.
This is an administrative thing, has no substance.
Okay, then I'll hear you out. And Ms. Brown, I just don't want you to worry that, wait a minute, I don't have a lawyer right now. He's hearing all these things from the state. Good news is there are 2 lawyers for your co-defendants here, and they would be jumping up and down if the state's asking for something haywire. Keep going.
So what it is, Judge, the first indictment, both Ms. Brown and Mr. Jones posted cash bonds. There's been a new indictment where we did not seek a new warrant or anything.
But there are additional counts.
Well, it's not even the additional counts, Judge. It's that we had asked if the jail, since the jail's holding that bond money, it's cash bond, if they could just substitute in the new case number. So that if we were to null process the first indictment, the bond wouldn't be returned. They're saying that they can't do that, or at least the person we spoke to, they said it's above their pay grade. So possibility number one, I was gonna ask if Your Honor could maybe reach out to the jail on that, or possibility number two, if we just left the first indictment open and didn't all process, because all this came about as, trying to clean up the first indictment through a null process. We could just leave it open through the pendency of the case and avoid any issues.
I prefer plan number one. If you will send to Ms. Nelson the contact information for the person you're dealing with, I'll see what we can do. Because it's the same bond, it's just transferring the funds that secured the first bond to, it's really what you said, it's changing the number of the indictment. Seems like it's doable. Failing that, my least favorite option of leaving a case open for no reason, except there would be a reason here, so that people don't have to post bond twice.
Right.
All right, done. So if you can, I don't, there are lots of people online, but they could be for some other matters. Who would I be seeing who's online and to find out if they have something they want to say?
The folks that I believe may be on are Kathy Butler, Sean Thomas, and Tony Burbridge.
Okay, I do see at least one of them. So I'll say this, if there's anyone on the Zoom call who wants to be heard, I'm happy to hear from you. If you are one of the victims in the case, know that the delay occasioned by Ms. Brown switching lawyers, one, is not the prosecutor's fault, but two, is sort of a necessary evil so that we have defendants who are being represented by lawyers with whom they have a good relationship, so that come trial, this case doesn't fall apart again because all of a sudden a lawyer says, I got to leave the case. My client and I have irreconcilable differences. So it's not uncommon for something like this to happen. It's not convenient, but it can happen. So having said that, if there's something brief and on point you want to share, I'm happy to hear it before we press on with our calendar.
Your Honor?
Yes.
I'm Richard Butler, and I am one of the victims. I've never been given an opportunity to do an impact statement because I just haven't been in an environment where I can actually talk during the proceedings. And my wife, Kathy Butler, is here next to me, whose name we're on. Basically, every one of these hearings we attend is triggering, to be quite honest. We've given away pretty much all of our retirement savings to this scam team here. And it seems like every time we come, one or more of them have a reason why they need to push this further out. And I understand accommodations need to be made to a point, but the fact that they want all these accommodations time and time again, and into here, there's no potential for restitution more than likely, but to have Kayla Brown come on today and say the lawyer saw her assets and that's when he increased it up. And just because you have over 100,000, don't mean she want to give it to him. This is all very frustrating that we're trying to figure out what to do now that I'm in retirement stage. Actually, I'm a disabled veteran. That, we're trying to figure out struggling things here. And they're talking about sitting on large amounts of money because of all the people they've scammed. And we got to sit here and keep watching this get pushed further and further out, Your Honor.
Mr. Butler, I appreciate you joining us this time, and it resonates with me when you describe attending something like this or other hearings relating to the case as triggering. It must be particularly galling to hear someone who you believe took your money wrongfully talk about, I got this money and that money. I must approach this, as I trust you understand, as a situation where the defendants are presumed innocent. That's how you would want it to be if you were charged with something. So in line with that, I also have to make sure that we're meeting all the requirements of due process, such as making sure you've got a lawyer, et cetera. And I'll add this only, I'm not making excuses for anyone, and I'm not in any way trying to minimize the frustration that you're feeling or the financial duress that the facts behind this case have caused you and your wife and the other victims on this call. That is very real. And it's got to be a wound that keeps getting poked at every time we get together. And what you're not hearing is, I'm sorry, and here's some restitution. But this case has taken longer in part because of steps that the state has taken. I'm not blaming Mr. Wooten, but the reindictment necessarily resets certain things. The state chose to add a defendant. That's not something Ms. Brown chose. That's not something I chose. Those were important steps and probably strategically appropriate for the district attorney's office to do. But that's something that adds in more time. And so I guess what I'm trying to say is there's frustration to go around everywhere on your part. And it's not simply, oh, the judge is accommodating the defense here, the judge is accommodating the defense there. The judge is trying to get this case in front of a jury as soon as is consistent with the rights of everyone involved. It's not soon enough for you or your wife or Ms. Burbridge, and I know that. It's my job to hear from you each time about your increasing frustration. But I do want you to know that there's a lot being juggled here, and I at least am doing my best to keep pressing on this one.
I appreciate it, Your Honor.
I appreciate you being here. Anyone else?
Yes, I have something to say. So
Welcome back, Ms. Burbridge.
No, I do understand the due process, et cetera, et cetera. Having dealt with this pathological liar for over a year, my concern is that this is a pattern and that stirring the pot with her attorney and not paying him, which I have no doubt that that is the case, is going to be a continued pattern, that she will hire another lawyer. This will happen again. At what point do we call it, no, you get a public defender, period, and we're moving forward? That's what I want to know.
Great question. Fortunately for you, this is not my first rodeo. And so if we are together again in a couple months and progress has been made, and then mysteriously lawyer number 2 says, wait, I haven't been paid, and there's this breakdown, that's all it takes. It doesn't take 3 or 4 or 5. 2 for me establishes a pattern. Either that lawyer is not relieved of responsibility because that lawyer is going in with eyes wide open. Lawyers can read between the lines as well. And lawyers often reach out to their predecessors saying, what am I getting into? But if someone is filing an entry of appearance on behalf of Kayla Brown, that person is saying, I'm in. And either I don't let that person out, or I say, if you want to break up with this lawyer, you can, but then you fly solo. You represent yourself.
So here's my other question. So say hot potato, none of them take it. Then in 2 weeks when we come back, you appoint a public defender, or she flies solo dolo?
It is all based on means. And so Ms. Brown could only have a lawyer appointed to represent her if she qualified financially. She has said things today to me in open court that suggest she doesn't qualify financially for public assistance. And so I'd be hard pressed to see that as an option. But the case law is very clear that if someone who can afford counsel but does not appear with counsel for whatever reason, I choose not to hire one, I keep firing people, I can't find the right one, that ends up being a situation where then that person represents himself or herself. And I'm authorized to move the case forward that way. My hope is we don't get there. That's a terrible outcome for that defendant. But to your point, that is something that a defendant has done in the past, where I know I can just avoid trial forever by constantly switching lawyers or saying I can't find one who suits me just right. And that's actually not how it works. And courts are empowered to say, you know what, you've had a chance. Trial is next week. You can have a lawyer show up if you can get one to show up for trial, but I won't be delaying trial because now at the 11th and a half hour, you're bringing in another lawyer.
I appreciate you laying out that roadmap for me and for everybody in the courtroom, so that is understood. Thank you.
Okay, you're very welcome. Anyone else? All right.
Yes, I would like to speak.
Okay, and you are?
Deanna Palmer. I've been on all of the trials via Zoom.
I can't see you if your iPhone, so I need you. There you are. All right. Hey, Ms. Palmer.
Hello, how are you?
Well, it's always depressing to hear from you guys because of what you've gone through. So I can't say I'm doing great.
And I concur. I've been depressed since this has happened. And I would be remiss to say that I care about her giving birth. I truly don't. What about me being able to sustain my family? out of the money that she scammed me out of? What about us? What about victims? It seems like she has a scheme. She is a scammer. Like, but without doubt, she has come up with the last to scam with a team. And like, why can't she be incarcerated until she became a lawyer and we get to move on? What happens for the victims in this situation? Like she just said, she had $100,000. You know why she has it? Because she took it from us. That's why she has it. That's why she's living the life of luxury on social media, flaunting the money because she scammed so many of us. And I'm very passionate right now to hear her say she has $100,000. That's my money, sir. I want my money. I can care less about any other thing she has going on. No lawyer, giving birth, any of that. Her mama, her brother, her uncle, anybody else is involved. What about me? She could care less. She has cared less. She has shown that she could care less. Family. I've known her since she was a little girl. And she just continues to live her life freely while I sit here and work 3 jobs just to make up for an investment that she scammed me out of. I feel like that's not her. Judge, I hope that you hear my cry. I am crying right now. My heart is bleeding to hear that she's sitting on $100,000 that she took from me, my children, my mouth, my roof, my retirement. This is deeper than her not having a lawyer. This is my livelihood. This is my family. This was trust. This was love. That's all I have to say.
Ms. Palmer, you should say it each time as long as you're feeling it. I appreciate you presenting again your frustration in this situation. And like I explained to Mr. Butler, my goal is to get this into a trial posture as soon as possible so you'd be in a position to testify and tell the jury exactly what happened in your situation. Thank you for joining us. Mr. Wooten, anything else from the state?
Only thing, Judge, as it relates to sending that email to Ms. Nelson, because Ms. Brown doesn't have a lawyer at this time, should I wait until?
No, it's purely administrative. Just send it from you to Ms. Nelson. It's not keeping anything secret from Ms. Moorman or Mr. Campbell. I said it here in court, so they know what you're doing. All you're doing is sending the name of someone who I might be able to chat with to figure out how do we move this bond money from case A to case A1. Okay, I appreciate your discretion in that, though, and wanting to include them. Ms. Moorman, anything on behalf of your client?
I do, Your Honor, and I apologize because this actually probably should have been a motion or a quick conversation, just moving, but I didn't know until I got here. And just briefly, Mr. Jones has a condition where he can't leave the state, and he has a son that's playing college football in Florida. So we've asked the court permission to allow him to attend some games. I don't know.
So that should be in writing. Step one would be to reach out to Mr. Wooten so that you can say the state consents or the state doesn't consent. And then if you get a motion for bond modification, then I can consider that. We don't need to have a full-blown hearing on that as long as we're getting input from the state. Okay, thank you.
Nothing further, Your Honor.
All right. Give me 1 second. Mr. Campbell, anything on behalf of Ms. Jones?
Nothing further right now, Your Honor.
Okay, you'll get that jump drive. Is it on your person?
It's on my person.
Excellent. All right, so don't leave the building without Mr. Wooten having received it.
I'll make sure they get it.
All right, that's it. Thanks again, Mr. Wooten.
Thank you, Judge. And may we be excused?
Almost. Yes, ma'am. How are you? I know who you are. Okay. Well, but is it?
I'll ask you guys.
Okay.
Can I come up with I'm not saying my
Yes.
And with that, Judge, may we be excused.
Yes.
Thank you.
Ms. Wood, I see that we've got Mr. Williams back. What are we going to do there so we can let the good folks with GDC go back to what they need to do?
Just a waiver today, Judge. I've explained to him, once I get discovery, I'll set up another call with him to go over everything.
Okay. Sounds good. Mr. Williams, I'm just putting you there so you're a little bigger on the screen. It may well be that your cases are worked out in fairly short order, but today's not the day. So Ms. Wood is going to file a waiver of arraignment, which is simply an entry of a not guilty plea in both of your cases. One of them you're charged with some drugs, another you're charged with having a gun as a felon. And then she'll keep working with the prosecutor to see if there's a way to work them out. It may be that you time out and are released, and then you need to come to court to do the rest of whatever needs to happen in your cases. Okay?
Okay, thank you.
When you get out, are you coming back to Fulton County, or where will you be living?
At this time, it's not well decided on, but it should be Fulton County.
Okay, it doesn't need to be. I'm just curious. When you get out, will you still be on probation?
Yes.
Okay, that's the important piece, is that when you get out, you're going to need to let probation know where you're living.
Okay.
They need to have an address on file.
I already have my address on file for Fulton County. Yes, I'll still be staying with my girlfriend.
Is that you? Okay, and you live in Fulton County? Excellent. Okay. Ms. Davis, anything on behalf of the state in connection with Mr. Williams's cases? Okay, that's it. All right, Mr. Williams, we'll see you around. Thank you, folks at GDC.
Thank you, Your Honor.
All right, I'll talk to you in a minute. Ms. Woods, if you could speak with my Lauren.
I'll get with her.
Thank you.
All right, bye-bye. What's the question?
Where is Miss Wood? Is she home or is she somewhere else or is she in the building?
She's not in this building. She's either in her office or in her home office. Her colleague, Ms. Rios, is right here, seated up front where I'm pointing. Can you wave, Ms. Rios?
I can give you, you want Ms. Wood's number? I can give that to you.
All right. Martavius Kemp. That had Mr. Wooten's name next to it. It's his case. He just left. Ms. Davis, are you handling that?
Yes, it's a regular problem.
Okay. I don't know why his name's not, maybe it's a typo. Kemp is his last name. Oh, right. What? Thank you for reminding me. I don't know, you reminded me, you reminded him. Let me deal with Mr. Kemp, and then we're going to talk about yours. The state has now had enough time to track down Ms. Willingham.
Oh, yes, Judge. I'm sorry. I finished it just realizing after the things going on that
Yeah.
I was handling it.
And what's the state's view?
I will defer to the court. I was not able to reach the victim. That's why I stepped aside. I did attempt to call him a couple of times.
Okay.
But based on the bond provisions that already allow nonviolent direct contact, I didn't see anything that's
Okay.
out that.
All right, we'll get all that in just a sec. Yes, ma'am.
I just have, like, maybe if there's something relevant in the software, whatever.
That's fine. She can talk with you in a second. Or right now. Hey, Mr. Kemp.
Hey, how you doing, sir?
I'm all right. I need to wait till your lawyer's right back here and we'll figure out what we're gonna do. You missed court and need to hear from her. All right, how are you?
She doesn't have my card. He did the one.
Right, we'll circle back to you right after we deal with that. Okay, thanks. Ms. Rios, are you handling Mr. Kemp's situation?
I am, Your Honor. I was just pulling up my notes on him because I didn't have a physical copy. Yes, I was asking for his his bench warrant to be set aside.
Okay, I'm pulling up his case now. All right, so Mr. Kemp, you had court in, looks like June, didn't make it. And there was a bench warrant, you got picked up. So tell me what happened, Ms. Rios.
Yes, Your Honor. So his sister was getting his mail and she did not open the mail. And so that's why he did not know if she had been good about letting him, because he can't live with that address with her. So she had been good at letting him know about when he had like anything that comes through, but she didn't this time.
Why can he not live at that address?
I guess him and that sister just don't mesh well. He has another sister though that he can live with, and I have the address for that sister.
When he was not living with the sister where he's not supposed to live, did he have an address that we could have in the system, or?
I think that was he was challenged homeless.
Bouncing around a little, okay.
Having the custody battle of the house.
So he was living with his grandmother and they were having a battle over the house or the state that she passed away. And so that created some issues for him.
Okay. But there's now an address where Mr. Kemp could be?
Yes, Your Honor. What was that address? What was the address?
125 Capitol,
That's the new address.
yes.
It's 125 Capitol Memorial Drive.
Memorial Drive, apartment 206.
125 Capitol.
Memorial Drive, apartment 206. Yes. The 878. I don't even know the number. I don't know that. No. I think it ends to just.
Are you ready are you looking something up?
Oh, I was just trying to make sure I had his sister's number, but no, I'm good. I'm just asking for his bench warrant to be set aside since he has a stable place to live. And it was because he was homeless at the time is where he didn't get the notice to come.
And why is this place available to him now and it wasn't before?
I think maybe he had to reach out to this sister.
Yes.
And so now he finally, when he was in jail, reached out to her and she said he can live there. Yeah, I believe he just did.
I can talk.
He wants to.
Hey man, if you're sleepy, you can go outside. You don't have to stay in here and be sleepy.
I wasn't staying with these sisters. The house, the address y'all had, that's my grandmother's address, but she died and they're having a custody battle over the house. So that's why I really staying with my big sister. So she been getting the mail from my grandmother's house while they go through the custody battle. But the sister.
Why does he want you to see my other sister to now?
Not my little sister. I was staying like my little sister. I can stay with her, but she didn't know that I didn't have an address.
It seems like he just didn't explain to his little sister that he did not have a place to go. Everyone was under the, I guess, impression that he was staying at the grandmother's house until he could no longer stay there because of the battle with the house.
Ms. Davis, what are your thoughts about this bench warrant situation and Mr. Kemp and the likelihood that he'll come back to court if I lift the bench warrant?
Judge, based on the information that has been submitted, it doesn't seem like there is maybe a designated place or space for him to receive mail, to get information about his case, to appear. I would also like to add to the record that the state has filed a recidivist notice in this case. This individual has 7 previous felony convictions, and so I do believe that the propensity to reoffend is very likely one of the Ayala factors. And so with that, we do not believe that the bench warrant should be set aside.
Okay. Ms. Rios, I'm a little uneasy, but if you can provide something from this new sister, I don't mean that it wasn't a sister before, but this opportunity that Mr. Kemp has where she says, here's my address, he can stay here, then I might be inclined to do it. But not necessarily through any fault of Mr. Kemp's. It sounds like he has had to bounce around a fair amount, and I'm just a little uneasy that the next notice would get to him. It was already a little tenuous if he was relying on a third party, admittedly a relative, to let him know when he had to go to court.
I will say the difference is now is I have a contact information and he has my number, and I'm really good at calling my clients to make sure they get to court.
You're very good when your clients have a phone and they keep that phone and it's charged and the voicemail box isn't full. My doubts aren't about your reliability. I don't know Mr. Kemp, and I want to give him the benefit of the doubt. The recidivist notice gives me a little pause. This is a set of allegations that involves a victim, an elderly victim. We already had one instance when Mr. Kemp didn't make it to court. And he's explained why. And I don't have a reason to doubt it, except that the explanation is my situation was kind of sketchy. And this new scenario maybe is more stable, but I need more than Mr. Kemp whispering in your ear, hey, no, it's this, I think it's this address and that. So if you, through your investigator, are able to get me a way to speak with this person and confirmation that her household is open to Mr. Kemp, not just when he gets out, but he could stay here while he's dealing with this case.
Yes.
Because if he could be here for a few weeks, then we're repeating the cycle.
Yes, Your Honor. Should I reach out and just have her send Ms. Elson an email? Okay, I can
Yep.
do that.
That'll work.
Can we also get an email because you don't have as a commanding having no access?
I will include you, have her include you in me.
That's great. We should all be in the loop. And I guess this case where the charges arise from an arrest in September of last year is not the basis for a revocation proceeding, or that's already happened?
No, he actually already had a revocation. I don't have the date, but we already revoked.
Okay. Whenever it happened, it's happened. So this isn't going to jump up and grab Mr. Kemp. Okay. Mr. Kemp, do you have any questions?
No, sir.
All right. Well, we'll see what happens. All right. Before we move down the calendar, where did the ankle monitor lady go? Hey there. Remind me again your name. Are you able to give me 1 second? Malik Lewis. Who is that to you? Okay. Are you guys still talking?
Yeah.
Can you get him on the phone?
Well, he's not gonna be able to answer the phone today because of his job, he's doing the training, so they can't have their phone on the floor, that's why I'm going to answer the phone.
Okay.
And they did not get in contact with him today, so.
No reason to think that was going to happen. What does he do?
He's a manager, well, he has an MBA, so I can't really explain it, but he's a manager over a warehouse. I don't know why they have an MBA, but it's stuff that I like, specific to the MBA, I don't even know exactly what he does, but he involves some important stuff with the warehouse. From Korea or something like that.
It's an important warehouse. Okay. Got it. Do you two live in the same household?
Yeah.
Okay. then I will remove the ankle monitor requirement. Ms. Rios, if you will get a proposed order in Word format to Ms. Nelson, I'll sign that. You'll need to take a copy of that order, because once I sign it, it'll get filed. Ms. Rios can send you that order. You take a copy of that order to Second Chance. Do you know where they are?
I'll find out.
You will find out. A Second Chance, you look it up, they're online, it's a bonding company. Call them first, because they have several offices. Say, hey, I got an ankle monitor, it needs to come off, I have an order from a judge. They'll tell you 123 Walnut Street. Go there, show them that, they'll remove the ankle monitor.
Okay.
All right? Everything else is still the case, it is still in, you didn't have any conditions of your bond, which is why it's weird you had an ankle monitor.
At first I was thinking maybe that she couldn't on there because I was born in a different state, but I don't know why. Even because my past public defender, Barry Brown, she wasn't even sure on why I had it on there, but we were just trying to get me out of jail because I was in there for almost 30 days.
Okay, well, strange things happen in court sometimes. Not today, though. Good things happened for you. So Ms. Rios will get me that proposed order. She'll get it to you once it's signed and filed, and voila, no more ankle monitor. I think so. You did the waiver, Ms. Rios, so do you need Ms. Woodson to stick around? All right. Thanks. You bet. And remind me of your name, ma'am. Right. Ms. Nelson, position 5 on our plea and arraignment calendar. Sydney Gibson was Ms. Faria's lawyer pre-indictment, but doesn't carry over to the indicted cases. Any information on who's representing her?
No, I don't have any information on that one.
Do you know, Ms. Rios, if your office has to put something in, or it's sort of self-evident because your office represents one of the defendants?
That and that Sydney Gibson was on the case, so it should automatically go to Mr.
Okay. Ms. Faria, did I already ask you if we have good contact info for you? Okay. Do we have good contact info for you?
No, because I didn't hear it.
All right. We'll go Second Chance. Do you have an ankle monitor? No, just you have a bond through them. Got it.
I need to change the address and.
Okay. I have an address of Delk Road with no apartment number, just says apartment. Okay. What I need you to do is write down on a note card, and Sarge should have, at least there used to be note cards over there. Look at that. A good address and a good cell phone number, and we'll pass that on to the lawyer who I suspect is going to be representing you, okay? Thanks. Sorry it took so long. Then you can go. Well, just make sure it's legible, whatever you write, because I have to read it and send it. Do you have good handwriting? All right, well, she's doing that. Ms. Heflin is next, and that is Attorney Lim, who I know has been on here. Hello, Mr. Lim.
Hi, Your Honor.
Ms. Clark, is this your case now?
The motion
Position
to withdraw
5.
the plea?
Yeah.
Yes, Your Honor.
Okay. And I think Ms. Heflin is on. Ms. Heflin, can you turn your camera on, please?
Hey, how you doing?
I'm well. It's been a minute. How you been?
I've been great.
Good. Ms. Clark, I'm going to give you a little context on this one, and then I'm actually starting with you. I know exactly what Mr. Lim's trying to do. Mr. Jordan, I believe, was the one who worked this case out with all the defendants, and Mr. Lim was simply the most proactive, and I believe Ms. Heflin was one of the very first defendants to resolve the case, first offender felony plea, and then defendant after defendant after defendant, it was misdemeanor, misdemeanor, misdemeanor. And unless Ms. Heflin is really fundamentally differently situated, it seems like to me, out of fairness and equity, she ought to have the same disposition. And maybe Mr. Jordan wasn't comfortable with that early on, or things changed. it's a little trickier for you because you weren't handling the case then. But while it's fashioned as a motion to withdraw a plea, I see it more as a, can we restructure this so that it is a similar outcome as all the other defendants? I don't know if you had a chance to look at the state's case and its theory of who was most culpable, but it was a whole bunch of people who supposedly mistreated this. I think it was a little boy. But the outcomes were somewhat disparate.
Yes, sir. So I did look at it, and I would not oppose it being restructured as you're talking, so that it will be fair.
Okay. Mr. Lim, if the state doesn't oppose it, my proposal is that even though we're out of term, if there's no objection, I don't think it's anything that we run into issues with. Thank you so much. That I simply enter an amended sentence where the count is reduced to the same misdemeanor that the other defendants pled to. And you can tell me whether Ms. Heflin wants to withdraw the first offender part because it's a misdemeanor and not a felony. And then that she gets sentenced the same way that the other defendants did.
Yes, Your Honor, if that is possible, that would be great because he's young. And the reason why she pled first was at that time, DFACS has her children and they would not give it back to her until she resolves this case. And so ADA Jordan at the time proposed this resolution, but thank you very much for hearing this.
No problem. I'm sorry it took a little while to get to where we are. Ms. Clark, do you have any objection to me handling it that way?
No, Your Honor.
So I'll look to the final dispositions for the other defendants and just have this mirror it. Mr. Lim, you'll know when that's happened because it'll go into the docket and then you can get it to Ms. Heflin and she'll have that as the new official sentence in her case.
Thank you, Your Honor.
All right. Ms. Heflin, do you have any questions about anything I just said?
No, sir, I don't.
Okay. Well, I think we're done with that then. If there's nothing else, you and Mr. Lim are free to go.
Thank you so much. Enjoy the rest of your day.
You too.
Bye-bye.
Yes, great. I don't know how I'm gonna remember. I'm gonna make a note here. Okay. Yep. Okay. All right, give me 1 second before we turn to the next one.
So
we don't get that a lot.
No, we don't.
Okay. Ouch. Ms. McBurrows is next.
Yes, and I've been in contact with the attorney, Mr. Booker. It was my understanding that he was going to skip your leg. I did have officers appear today.
Okay, he's on. He just appeared right there on the screen. Hey, Mr. Booker.
Hey, Judge, I'm here. I expect we're going to stipulate and just argue regarding disposition of what sentence she gets.
Okay. We're going to bring Ms. McBurrows out.
Okay. Her dad should be on the call as well.
He tried that last time. I know, but this time he stipulated.
I see that Ms. Gardner is back on too, so I think we can close that plea out after we do this. Can you slide over a little bit that way? Perfect. Thank you. And let me get that on. There we go. Okay. I need one more document. Let's see if I can find it. Yep, there it is. Ah.
Just mine.
Yeah. Okay, we'll work through it. The what? Yeah, why don't we try that? Okay, Ms. Rivers, you ready to get on the record?
Yes, I am.
All right, this is position 6 on our inquiry and motions calendar, State versus McBurrows, 22 SC 182239. Ms. McBurrows is here in court. Good afternoon.
Good afternoon.
Her lawyer, Mr. Booker, is online. You see him on the screen?
Yes, sir.
Great. We have Ms. Davis for the state. And Ms. McBurrows, you are here because I signed a probation warrant in your case. It's really not legible, but I'm going to get a copy of the petition, which is the companion document, and I'll be in a better position to say, here's why we're together. But it looks like you got arrested for some new charges while you were on probation, which is a problem. And we were originally going to have an evidentiary hearing where the prosecutor would call in witnesses who would testify, here's what happened, we caught Ms. McBurrows doing this or that. The state's burden of proof in a revocation hearing is pretty low. It's not like at trial. But Ms. Davis has been speaking with your lawyer, Mr. Booker, and it sounds like what we're going to do instead today is that we're going to just have a discussion about what the consequences should be for your violations of probation. Does that make sense?
Yes, sir.
Yes? Okay, great. And I don't have the petition yet. Here it is. So we're clear. It's alleged in the petition and in the warrant that a long time ago, December of 23, you had a shoplifting arrest in Clayton. And then a year later, December of 24, in Cobb County, you were arrested for false information and a little bit of marijuana. And just 4 days later, a shoplifting in Gwinnett and another one in Gwinnett in June, and burglary in the second degree in DeKalb. That's a lot of stuff. Mr. Booker, is Ms. McBurrows stipulating to these arrests?
Yes, Your Honor, for purpose of this hearing, she's stipulating to the arrest.
Okay. Have any of these cases been resolved, or are they still just sitting out there?
Well, Judge, in the Gwinnett case, I'll just kind of go in order. In the Gwinnett case, the co-defendant has taken a plea and resolved it. And as I understand that he intends to or is going to exonerate her, he is actually in custody of DeKalb County now, but he apparently at the plea in Gwinnett provided information to the court that I expect will exonerate her on the Gwinnett charges. Well,
Okay.
he's also her co-defendant on the Cobb County misdemeanor case. And I anticipate on that case, because there was marijuana between the two, that he is going to exonerate her of that. The DeKalb case is the bigger issue. In DeKalb, that case is also still pending. In that case, she was working as a security guard in a business ultimately, and the allegation is that she entered a part of the business she should not have entered and took a laptop, is essentially what that comes down. That's why it's charged as a burglary. Judge, my client's father is on. He's had custody of her, I guess, pretty much her whole life. I learned from them that I did not know initially is that she has had a prior mental health diagnosis. She has personality disorder. It's along the same lines as bipolar. She's been taking medication since she was a child, or at least supposed to. She has gone through this time frame where she stopped taking her medication, and she ended up hanging around some different people. At least 2 of the 3 cases are involving the same person. And I believe, Judge, and I know the state's asking for custody, and I get the fact that there's a lot going on in a very short period of time, that the behavior is not about her being a bad person. I think the behavior is the fact that she just was not taking her medication. And I think her dad would say that. She is 3 months or 4 months pregnant. I guess she can tell you which. And she does have a 5-year-old special needs child that her dad is taking care of right now. He's on the line as well, and he wants to be heard.
All right. That was helpful background. I appreciate it. Question. You mentioned that there was a gentleman who took the rap in Gwinnett and May also in Cobb, or the other way around. I think it was that way. Who is that? What's that person's name?
His name is Brandon. If I could switch over to my notes, Judge, that she knows his last name. What is his last name, Ms. McBurrows? Brandon what? Brandon Harris.
Harris.
Yeah, he's taken a plea before Judge Warren Davis in Gwinnett County on that shoplifting case.
Okay. Is he the father of the child that you are going to have? No. Okay. And Mr. Sexion, he's not.
He's incarcerated.
He's not in the picture in any way. Okay. All right. So that's helpful background, Mr. Booker. And since Ms. McBurrows is stipulating all the arrests, we don't need to have a back and forth about that a whole lot more other than whatever the state wants to present, which I'll hear. What are you advocating for, Mr. Booker?
Well, Judge, I know when I was last there in court, the state was asking for her to go to prison. And I can say in some ways I can understand that. At that time, I did not know about the mental health diagnosis for personality disorder. Again, I think it's a bipolar type disorder. I know she's had depression, ADHD. She's been on medication for a fair period of time, and her dad can elaborate more on that. I think he's had custody of her since she was a young child. But I'm asking the court not to send her to prison, to return her to probation and put as a condition of her probation that she get a mental health plan in place where she is taking her medication. She's willing to do a HIPAA release for probation to have access to the fact that she's taking her medication. I'm not sure if she needs to do a mental health evaluation, but I don't think she's currently seeing a provider. She is 3 months pregnant, Judge. I get the fact that there is a punishment to be paid. When you're on probation, it is a benefit to you. It could have been a case where she went in custody, but I'm asking the court to, she's been in custody about 60 days, I think, at this point, is to revoke her for that 78 days. Okay.
Yes.
For almost 90 days then. So she's between 78 and 90 days, 70 and 90 days. I'm asking the court to revoke her for the time that she has served and to reinstart her on probation. Again, she hasn't been convicted of any of this stuff. I think a lot of these cases will resolve themselves in time. But I do to get the fact in a very short period of time, she had a lot going on.
She did. And I think one of the cases you didn't mention was the Clayton case. That's the one that's super old. Any idea what's happening with that one? That's another shoplifting.
Thrown out. It got thrown out.
Oh,
Didn't know there was a
it got thrown out.
Okay. Yeah, I didn't have that one on my list. I only had the DeKalb, Gwinnett, and Cobb.
Okay. I'm sorry, Ms. Simpson. What'd you say? The Clayton County misdemeanor? Okay. All right.
And her dad's on, Judge, whenever you want to reach to him as well. His Terrence McBurrows, he's right there on the screen.
All right, Mr. McBurrows, was there something you wanted to add?
Dad, you got to turn your mic on.
Yeah. Hey, how you doing, Your Honor?
I'm okay. How are you?
I'm okay. Like the attorney was saying, my daughter, she does supposed to be on meds and stuff, and she's been off them for quite a while. Not necessarily trying to use them as an excuse, for what occurred, but she's a great, bright child of mine, and I just feel like she been around the wrong person. She have to make better choices, in life. And upon her release, she'll have somewhere to stay. She'll be moving in with me and my wife, and I'm taking care of her child right now while she's away. So I'm just trying to make sure she stay out of trouble, and hopefully, she can get back to getting things together with her health, with her mental health, and so far.
Okay. Well, she's fortunate to have you present in her life in that way. And I think we're all grateful that you stepped up to take care of her son while she's working through this. Where is your residence if she'd be staying with you? I don't mean street address, but is it in Decatur? Is it in Atlanta?
No, it's in Union City.
Okay. And you have space there where she could stay, her son could stay, and
Daughter.
Yes.
daughter.
Yes. Well, her daughter, yes. I have a daughter right here, right now, running around. Yeah, I do have space, an extra room for her.
Well, and there's going to be another one soon too.
Uh-huh.
Room for that one also?
We had to make me and my wife had to make arrangements to get a bigger space, but for now we do have room for her and her child.
Okay. All right. Thank you for plugging in.
No problem.
Ms. Davis.
Thank you, Your Honor. I can appreciate counsel sharing with us some of the mental health challenges that this defendant is facing. Also, the fact that she is expecting a child. It's not my intention to advocate for anybody to be in custody and give birth, but given the litany of cases that have occurred, 4 or 5 cases, while she's already on felony probation, I think we may need a little bit of time in custody to kind of deter this behavior and the path that she is on. I know probation is requesting 2 years. I think that it would be a little high, but I do think releasing her today would not be enough. And so I will defer to the court on a happy medium in between those two asks for Ms. McBurrows.
Okay. Ms.
And
McBurrows.
Judge, can I add one
Yes.
thing?
Yes.
If you're going to give her further custody time, Judge, we'd ask that you make an accommodation where she's able to at least be able to give birth to her child when she's released. I understand that obviously during the current case law, anything that you revoke, she's not getting credit for the time, which is still an interesting case to me. That she's not getting credit. She's not getting credit for the time that she has against whatever sentence you give her. And I believe
Right.
she has a hold for Gwinnett that she's still going to have to appear and address that case as well. So again, she still has to bounce her way through the system, and I'm just asking you to take that into consideration.
Okay. No, I appreciate that. And I have to be reminded from time to time by Ms. Simpson, who is my DCS partner here in court, that I can't give credit for time served. And so if I settle on a number, I always need to subtract the amount of time that the probationer has been in custody. Our system shows 65 days, not 70, but it's not going to matter here. It's between 60 and 70. Ms. McBurrows, Mr. Booker mentioned it. I just didn't write it down. You are pregnant. How far along are you?
4 months.
You're 4 months? Do you have a due date or that's too far out?
Too far out.
Okay.
Judge, I forgot to mention, obviously, her father is there. She could be placed on an ankle monitor and house arrest if the court wanted to have her in further confinement time as well, so she can get prenatal care. But again, that's the last thing I have to say. I'll mute it out from here.
Okay. Each time you've chipped in, though, it's been helpful. I appreciate that. Last thing, Ms. McBurrows is a first offender right now. I suspect Mr. Booker wants first offender status to remain in place. Does the state or in talking with DCS, has there been a development of what should happen with that?
We didn't, I don't think, had a conversation about first offender. At this time, we're not seeking to revoke it because right now these are just kind of allegations, although some of the reports that I read are substantive. But at this time, we're not seeking to revoke first offender status.
Okay. Got it. Ms. McBurrows, is there anything you want to add or any questions about anything we've discussed?
Yes. Is there a possibility of house arrest or going to a program or anything like that?
What kind of program do you have in mind?
Like Hope program or something like that. I'm actually in a program while I'm incarcerated, and I have some certificates for the things that I've completed, like anger management. I've done 21 days of anger management. I've done parenting class. I have a cosmetology, a cosmetology scholarship for any school that I wanted to go to. I've got my PEACH certificate. I have a couple of certificates actually for the classes that I have completed. So I am trying to comply and just be back into normal population.
Well, have you been at the city jail? Is that where you're being housed at ACDC?
DC, yes, sir.
Have you been taking medication while you've been there?
Yes.
And what is the medication supposed to be treating?
For my mood disorder and my depression and anxiety.
Okay. When you were not at the city jail and were bopping around with that gentleman, Harris, you said was his last name, Mr. Harris, were you taking your medication?
No, I was not at all.
Was that because you didn't like it or you didn't have it, or why would?
I didn't have it, and I didn't have a provider at the time because I
Okay.
was moving around and doing a lot of things.
What makes you think when you do get out, whether that's tomorrow or in 6 months or in 2 years, that you'd have a provider so that we could keep you on the medication you're on?
My dad has a list of providers, and we've been actually going over providers over the phone, and I'm willing to try them and get back into therapy and counseling.
Okay. Got it.
And
Okay.
she's fine with an added special condition of her probation. I know I said I wasn't gonna say anything else. She's fine with adding a special condition of probation, judge, that she takes it, because I think that kind of gives the court some leverage if it's a special condition versus a general condition, that she has to comply with whatever treatment her providers require. I did speak to Ms. Davis yesterday. She was very helpful in getting us to this position, but I just don't think it's a 2-year revocation, judge. And again, her dad and I were on the phone last night. He has been trying to get her lined up with treatment. I think she was possibly self-medicating with marijuana rather than taking the drugs that she was supposed to take because she just didn't like taking them, as I understood.
Yep. Okay. I understand. So Ms. McBurrows, I find that you did violate the terms and conditions of your probation by all these different arrests you've had. You weren't out very long from your first case before some of this kind of stuff came up, and then it did happen a bunch of times. Mr. Booker has helped me understand what was going on in your life at the time. And it's not that you were sort of a human crime machine, but you were working through some issues without getting the medical help that you probably should have, whether that means the medication or the actual one-on-one contact with a counselor or a doctor. We need to make sure that doesn't happen again. You are seeing now the impact it has on your daughter. She doesn't have you around. And if we fast forward, it's just 5 or 6 months, and there's another little one around. And it doesn't help them in any way if you check out for a year because you stop taking your meds and take up with the next Mr. Harris or the next Mr. Sexion. And it sounds like these guys take advantage of you because they know that you're vulnerable and they do what they do with their lives, but make you a part of it. And their lives are, we steal this, we break into that, and you're suddenly in the mix.
Yes, sir.
But you are also at an age where you can't say, I didn't know any better. No one's going to buy that story. So hopefully with family support, your father and his wife, you will stay on track with taking a medication that helps you make decisions in a better way.
Yes, sir.
Ms. McBurrows, in light of your violations of probation through these multiple arrests, I'm going to revoke 4 months. I will shorten that revocation if Mr. Booker brings to me information from the doctors that you're about to have the kid. I do not mean for you to give birth while you're in custody, but you should have 5 months left before you give birth. And so the next 4 months, you're going to be in custody. I'm going to modify your probation to add a special condition that you submit to a mental health evaluation when you are released, and that you follow any course of treatment that that doctor recommends. Take this medication, take that medication. That doctor will have access to your medical history and probably won't be having you take anything new and different that you haven't taken before. And if you are prescribed medication, it's a requirement of your probation to take that medication. If it's giving you side effects you don't like, talk to the doctor, and that doctor can say, oh, we'll do a different medication. But you don't decide on your own, I'm done with these pills, I'm gonna smoke this joint or take pills that I get from my new boyfriend. That'll be inconsistent with probation. It's gonna lead to the same kind of stuff anyway. And your first child and your soon-to-be second child need you to be around and focused on them and not these other things. I'm leaving in place your first offender status, but it is hanging by a thread. If we are together again because you got arrested for anything, then I'm gonna resentence you on your original case. That doesn't necessarily mean you're gonna go to jail a whole lot more, but what it will mean is that you'll have a felony. And so this vision you have, which is a great one, that maybe you're gonna go to cosmetology school, learn a trade, try to practice something like that. You have to have a license to do that. And they don't hand those out to folks with felonies so easily. So you have a lot riding on keeping your first offender status. And I hope that that keeps you focused on staying current with your medication and making a different set of choices as well. I think I covered it in terms of conditions. Any other conditions you'd want to see, Ms. Davis?
Judge, I don't have all the defendant or co-defendant names, but I would like to submit the co-defendant names that we do know, that she stay away or have no contact with them if possible.
Well, it's already a condition of her probation that she have no contact with Mr. Sexion. That's, I don't know if I'm saying his name correctly. That's the co-defendant from what I'm calling your case, the robbery to which Ms. McBurney pled. But you also need to stay away from Mr. Harris. What's his first name?
Brandon.
Brandon. So Brandon Harris. And he may have been someone important in your life for a while, but he was important in some ways that were not healthy and safe for you.
Yes, sir.
So he'll need to not be in your life either while you were on probation. I thought about that. I'd like to do that as long as that's not going to be overreaching with them.
No, it'll just change her policy.
Okay. I'm also going to request, I can't make probation do this, but I'm going to request that you be assigned to an officer who specializes with probationers who have mental health needs, because that person is going to be much more fluent in what you can talk about. I take this medication for this, and it'll just be a better fit. Okay? Mr. Booker, anything else on behalf of Ms. McBurney?
No, Judge, I appreciate the consideration for you and from the state.
Okay. I hope this works. More so for Ms. McBurney's daughter and her child to be. I care about Ms. McBurney as well, but she's a grown-up and she's making decisions now. And I hope it doesn't reach a point where either your father has to step in or DFACS has to step in and say, you're not someone who can be around these kids. That would be real sad for those kids and for you. I hope you can be a good mom for them as you go forward. Okay? Any questions about anything?
No, sir.
All right. That's it.
Thank you, Judge.
You're welcome.
May I be excused, Your Honor?
Yes, sir.
All right. Have a good weekend, Judge. Thanks.
You too. So, Ms. Clark, Mr. Gordon, and Ms. Gardner, let's close out this. It has lasted forever.
Good afternoon, Judge. How are you?
I'm all right.
Barry Jones here from Mr. Johnson, and of course, Randy, I see you got a lot going on, but just want to let you know we're here and ready.
Got it. Appreciate it. We will turn to that as soon as we clear up the calendars that were just before it. Ms. Gardner, can you turn your camera on, please?
Can you hear me?
There she is. All right. Whoops. Okay, Ms. Rivers, we're going to turn one last time to the Foster Gardner case, which is from our trial calendar. We have Ms. Gardner back on the call. Her lawyer, Mr. Gordon, is on the call, and Ms. Clark is here in court. Mr. Gordon, when we had to pause, you were sharing with me that it was your understanding that the negotiations were actually not for a plea, but were for Ms. Gardner to be able to participate in some diversion program, the result of which would be the dismissal of the charges. As I understood it, the state had agreed to reduce the felonies to misdemeanors and we were working through that misdemeanor plea. Did you, Mr. Gordon, have enough time to speak with Ms. Clark about where those negotiations had landed?
Yes, Your Honor, and also I would like to apologize on the record to Mrs. Clark. She indeed did send via email August the 1st the terms of the agreement. However, it was an oversight on my part. I was still under the impression of a pre-conference that we had on July the 8th. And even in that particular pre-conference, there was some misunderstanding. I was under the impression that the Families First program was indeed a diversion program.
Okay.
But we've gotten that cleared up.
Okay.
And so we're going to accept the state's offer. We do have a negotiated plea, Your Honor.
Okay, appreciate that update. Thank you so much. So Ms. Gardner, well, first of all, is that your understanding as well, Ms. Gardner?
Yes.
Okay, where we left off was I had heard from Ms. Clark. You had answered all the questions that one answers during the course of a plea, and then I had turned to Mr. Gordon. Was there anything more, Mr. Gordon, you wanted to add on behalf of your client?
Only that I think Mrs. Gardner is a great candidate for the Families First program, and we just ask that the court accept the recommendation.
Okay, Ms. Gardner, anything you want to share?
I appreciate you for being lenient about me coming to virtual court and picking up my kids. I was definitely stressed out about it, but I just want to put on the record that I appreciate you for being lenient about that.
Not a problem. Sometimes life introduces those wrinkles where virtual appearance makes more sense.
Yes.
So I have a question for you. I hope and trust that it has weighed on you heavily that your child, Parker, was so injured, had these fractures. What is your theory? What happened to Parker? Some of those bones don't break real easily.
Well, Parker came out a very strong baby. He was kicking his way when he was born. He was very active, always moving, and I just believe he was just swallowed wrong.
Okay. How is he now?
Oh, he's awesome now. He's 2 years old. He's in school now. He's walking, running, runs faster than his older sister, who's 3. You wouldn't even be able to tell that anything, that he had anything that happened to him as far as his leg goes. We have the pediatrician doesn't have any concerns. We're working right now to get him into feeding therapy, so that he can work on the transition from the bottle to solid food. But other than that, he's perfect. He knows his numbers from 1 to 20. He knows all the letters in the alphabet. He can tell you his colors. He knows majority of the animals on the farm. He's extremely intelligent.
He knows the farm animals. That's always important. I remember that too. All right. Well, I appreciate you sharing that. Ms. Gardner, I find that your plea is knowing and voluntary, meaning you've understood what we talked about. No one forced you to enter the plea, and that there's a factual basis for that plea. Mr. Gordon, do you authorize someone in my office to sign the indictment on your behalf?
Yes, Your Honor.
Ms. Clark?
Yes, Your Honor.
Ms. Gardner, can we sign your name to the indictment indicating your misdemeanor plea?
That's fine.
Great. So I will follow the negotiated recommendation, which is for each of the 3 misdemeanors, a sentence of 12 months probation. Those will run consecutive to each other, so it's a total of 36 months probation. The sole special condition of your probation is that you enter into and complete the Family First program. I'm going to require that you enroll in that within the first 3 months of your probation. You can do it tomorrow if you want, but it needs to be within the first 3 months. And if you successfully complete that program, and it's a whole program, it's not just one class, then Mr. Gordon can reach out to me to think about ending your probation early, which I will be inclined to do if you do complete the Families First program. Ms. Clark, anything else in Ms. Gardner's case?
Just wanted to add, Your Honor, Ms. Gardner has already submitted her application to the Family First program, and so she has been accepted. To the
Great. All right, well, you need to encourage Mr. Foster to get working on that, Ms. Gardner.
Will do. Will do.
Yeah, Mr. Garner
Oh,
as
no,
well.
yeah,
Both of them.
everybody's been accepted. Yeah.
Yeah,
So
everybody's been
I think I
accepted,
just
sorry.
have to call the lady on Monday to kind of get things going as far as that goes. And me and my lawyer have already kind of talked about that. So yeah, at this point, I just have to call her on Monday.
Okay, sounds good. Well, that's it then. Thank you, Mr. Gordon, for your time.
Thank you, Your Honor.
All right, bye-bye.
Bye-bye.
I know you remember who this director is on here. This is Officer Jones. He's new to our office, and he was just shadowing.
Excellent. How you doing, Officer Jones?
I'm good. How about yourself, sir?
All right. Are you new to all of DCS as well, or just new to Fulton?
I'm just new to the court side. I was a field officer.
For how long?
2 years.
Is it good to be inside, or you'd rather be back out on the street?
I'm very willing. I'm eager to know another system.
Good. It's good to learn both sides, and then you can decide which way you want to go forward.
Yes, sir.
Good. Have a good weekend.
You too.
Judge McBurney, before we go to the 3:30 calendar, I need to go back to my office and get my binder. I didn't anticipate being here.
Stuck here waiting on
For
that.
that plea, I thought I was gonna have an opportunity to go back to the office.
Okay, go grab your binder. I think we've got a couple things we still need to deal with. What are we doing with Mr. Gould? Is Mr. Gould here? Let's see.
I think from yesterday, all we have left is John Davis to the probation revocation.
Hey, are you Mr. Gould?
Yes, sir.
Great. If you slide over a little bit that way, your lawyer's gonna, oh, is Ms. Wood, Mr. Gould's lawyer?
Yes, Judge.
Okay, actually be right in the middle. That's perfect. Let me add Ms. Wood. All right. Are we ready?
Yes, Judge.
All right. Ms. Rivers, this is a case from yesterday on our add-on calendar. It's 24 SC 006-502. Mr. Gould is here in court. His lawyer, Ms. Wood, is online, and our prosecutor, Ms. Davis, is here in court. Mr. Gould, I'm Judge McBurney, and Ms. Wood tells me that you are ready to enter a plea in your case. Is that right?
Yes, sir.
Okay, we're going to do that. Before I let Ms. Davis take over, you have a right to be here in open court, which you are, but also to have your lawyer, Ms. Wood, right next to you. So if you got a question, you can say, what's the judge talking about? She's appearing virtually today, which is okay. If you need to speak with her privately, will you let me know?
Yes, sir.
Okay. She also has a law partner right behind you, Ms. Rios. So Ms. Rios might be able to answer your question as well so that we don't have to figure out how to connect you with Ms. Wood online.
Yes, sir.
Ms. Davis, when you're ready.
Please raise your right hand. Do you swear or affirm the testimony you will give in this matter before the court will be the whole truth and nothing but the truth?
Nothing but the truth. Yes, ma'am.
Okay, you can put your hand down. Please state your true, correct, and legal name for the record.
Tyreek Gould.
Can you spell your first and last name?
Tyrek. My first name, Gould. My last name.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there any medication that you normally take that you have not taken today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 21 years old and I made it to the 12th grade.
What high school did you attend?
South Atlanta High.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you're charged with the following offenses: aggravated assault and possession of a firearm during the commission of a felony?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer, Attorney Wood, about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Attorney Wood, do you waive formal reading of the indictment and any and all defects therein for the purposes of this plea?
We do.
Mr. Gould, do you remember being arrested on these charges?
Yes, I remember. I just don't remember the year.
Your Honor, the state is unaware of any outstanding warrants related to this matter. Attorney Wood, are you aware of any outstanding warrants related to this case?
I am not.
Mr. Gould, has your attorney advised you of the minimum and maximum sentence for each charge to which you are pleading to today?
Yes, ma'am.
For aggravated assault, the minimum is 1 year, max is 20 years. For possession of a firearm during the commission of a felony, it is 5 years consecutive. Do you understand that today you're entering a negotiated plea of guilty, which means the state will make a recommendation to the court?
Yes, ma'am.
Do you understand the court is not required to accept the state's recommended sentence?
Yes, ma'am.
You understand the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
Do you understand that there are multiple charges to which you're pleading guilty today, and the court has the right to run those sentences consecutively or one after the other?
Yes, ma'am.
Attorney Wood, is your client seeking to be treated as a first offender?
Yes.
Mr. Gould, are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever pleaded guilty to or no low to or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for a crime, felony or misdemeanor under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty and you could be resentenced to up to the maximum sentence for each charge on this
Yes, ma'am.
indictment?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as other jurisdictions, including federal courts?
Yes, ma'am.
Do you understand that if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation just like a conviction at a trial would? That's true regardless of any advice by your attorney or anyone else.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm or use a firearm in a crime, you would be guilty of a felony, which may carry a sentence from 1 to 15 years in prison?
Yes, ma'am.
Do you understand there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following trial?
Yes, ma'am.
For example, your guilty plea may affect the right to vote, hold public office, to serve on a jury, to obtain a passport, to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're going to give up the following rights? I'm going to read about 9 to you. Once I'm done, I'm going to look up and ask, do you understand, okay?
Okay. Yes,
Give-
ma'am.
You give it the right to a trial by jury, the right to remain silent and not to incriminate yourself,
Yes,
the right
ma'am.
to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal a convicted of these charges after a trial. Do you understand that?
Yes, ma'am.
Do you understand that you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
How do you plead to the charges in indictment 24 SC 006502 to count 1 of aggravated assault and count 2 possession of a firearm during the commission of a felony? How do you plead?
Plead guilty.
Has anyone forced you, threatened you, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
No, ma'am. Can
It's
you
not.
repeat that for me? I'm sorry.
Is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, ma'am.
Your Honor, the state believes that the evidence would show in trial that on May 19, 2023, Officer Bogan with the MARTA Police Department responded to the Civic Center MARTA station in regards to a report by the victim, Mr. Anthony Powell. He reported that at the location 216 Peachtree Street, Northeast in Atlanta, Georgia, in Fulton County, that he was approached by the defendant, later identified as Tyreek Gould. And the individual was running up and down the MARTA train with a handgun, showing it to the victim, and then telling him he would hurt him. These actions caused Mr. Powell to be in fear for his safety. The officers did review the camera footage on MARTA, and they were able to capture and actually see the incident. It didn't really appear that he was trying to point the gun at the defendant, but he was playing with the gun, kind of taunting him, having a confrontation on the MARTA station. It's my understanding that Mr. Gould does not have a felony history. This may even be his first offense. And so we are recommending a probated sentence. It would be a 6-year sentence. So 1 year on the aggravated assault plus 5 years consecutive for the possession of a firearm during the commission of a felony. We would like the individual before us to submit himself to a mental health evaluation and complete any treatment if that is required, 40 hours community service, and obtain his GED if he does not already have it, and no contact with the victim. I believe the victim actually identified the defendant because from his job. I'm not sure if they worked together or he just saw him at the job.
And that's Mr. Anthony?
Yes.
Okay. And tell me what about the situation prompts you to make the recommendation that Mr. Gould have the evaluation?
It did, observing it physically, looking at the video footage, it did seem like something else was going on and something was present. But obviously if the mental health evaluators see that there's nothing there, then we can, move on. But it did seem to be something going on with him that day. And it may not be mental health, it may have been
A substance.
A substance.
Okay, got it. Thank you for that. Good afternoon, Ms. Hardy. Can you share what criminal history information you have on Mr. Gould? If you have his info, it's actually a calendar from yesterday, so you may not have had that.
I was able to pull it up.
Excellent.
There are three arrest cycles in Georgia, no felony convictions, and the only FTA appears to be from this case.
All right. Thank you so much. Ms. Wood.
Thank you, Judge. So this was a 2023 incident. Mr. Gould would have been 19 at the time. I totally understand why Ms. Davis would consider the possibility of a mental health situation, because from the video, you watch it and you're like, why in the world would anyone do something so dumb on the MARTA train? I don't personally think there's any mental health issues involved. I think it was just a stupid decision by Mr. Gould, but I completely understand her reasoning for that. Judge, they did work together at the time. I don't believe Mr. Gould had any intention other than making whatever statement by having a gun and saying those words to Mr. Powell. And so that's why we're here accepting responsibility today, Judge. He's 21 years old. He'll turn 22 tomorrow. He's a girl dad. He's got 2 daughters, a 2-year-old, and he just had a baby. And the newborn is why he actually ended up missing court on, I believe it was July the 10th. He was in the hospital with his partner who was on the Zoom call, Ms. Price. His phone was broken. And then of course, that's why he didn't get all my frantic text messages and calls. Judge, he has an 11th grade education. He does not have his GED. He understands the importance of getting it. Prior to getting picked up on the bench warrant, he was working at the airport. And before that, he had worked at Grady as well as Emory. We are asking for a first offender. I think he's a good candidate, and I'm asking for a behavioral incentive date as well.
Mr. Gould, is there anything you want to add?
I just want to say, back then I was young.
Because you're so old now.
Yeah, it's like them 2 little girls, they need me.
They do.
And I just see it, like there was just little boy materials. I lost my job behind that, but I still ended up getting, when I got out of Wright Street, I ended up getting more jobs because I'm a hardworking man. Like I'm not no street guy. None of that. I don't be in the streets.
Your 2 kids, 1 mom, 2 moms.
2 moms.
When you get out, where are you going to stay?
with the one that I just had the baby with now.
That's Miss Price?
Miss Price. Yes,
Okay.
Well, I'm sorry to interrupt, but.
You're not interrupting.
We actually stay together now. We've been staying together for a minute now.
Okay. Does Miss Price work?
Yes, ma'am. I mean, yes, sir.
What does she do?
She work at Grady. She's a unit clerk on 11A.
And what are you going to try to do when you get out?
I'm going to get me a job. I already got the allied security job set up. She got it set up for me as I've been on the phone with her as I've been incarcerated.
So you are asking to be sentenced as a first offender, which I'm going to do, and that is mostly a benefit. It means that when you get out and are back on the streets, you do not have a felony conviction, and that helps 110% with finding a job. You've been fortunate that you look for a job, you get one. Look for a job, you get one. You're young, you work hard, and you don't have a criminal history. But you can erase that I don't have a criminal history if this sentence doesn't go well for you. And I need you to understand the downside of first offender. If we are back together again in 2 months, 6 months, 2 years, and you've been arrested for something, I can revoke your first offender status. I would resentence you in this case. And I'm telling you, if you get arrested for something that involves guns, I will resentence you in this case. And I have 25 years to work with in this case. And I don't say that to threaten you. I'm not a real threatening guy. Just to be a real matter of fact, if Mr. Gould and Judge McBurney are together again while you are under this sentence and it's you and guns and something, I will take away your first offender status, resentence you, and it will involve prison time. And that's just this case. You're going to have those new charges that'll be in some other judge's courtroom. So you just need to be thoughtful about what you're doing. You sound thoughtful, but you need to act thoughtful as well. You are older a little bit. You've got 2 kids. You've got a young lady who cares a lot about you. She sat on this call for a bunch of hours, and you let all of them down if you go back to that foolishness that everyone could see on the MARTA train. And I don't need to be on a MARTA train. It's just, you pull up your shirt and you got a gun there. You can't have a gun while you are a first offender probationer. So it's going to be a shift in mentality. I hope you're ready for it because you'll need to do it. I find there is a factual basis for your plea and that your plea is knowing and voluntary. Knowing meaning you've understood what we talked about. Voluntary meaning no one's forcing you to enter the plea. Do you agree with that?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act, and I will follow the recommendation. I will sentence you on count 1 to 1 year and count 2 to 5 years. Count 2 has to run consecutive to count 1. That's 6 years probation, 5 plus 1. Special condition number 1 is that you get your GED. And I need you to enroll, it's a condition of your probation, that you enroll in that GED course within the first 3 months of your probation. You don't have to finish it, but you started it. I'm starting to take those classes so I can get my degree.
Yes, sir.
You'll need to complete 40 hours of community service and have no contact with Mr. Anthony. Did you know the guy?
Yes, we actually worked together. So it was like when I first started working in Emory, he trained me. So the little distraction we had, I don't know why it happened.
Well, it needs to not happen again because you can't be around him anymore.
We no longer work together anymore.
I bet. And I will set a behavioral incentive date of August 9th of 2028. That means 3 years from now, if you've gotten your GED, done your community service, and basically stayed out of trouble, the case goes away. They can end your probation early. Which is valuable because if you're a first offender, this whole tension of I can't mess up, once they close out your case, you don't need to worry about that anymore.
Sir.
Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
Ms. Davis?
Yes, Your Honor.
And Mr. Gould, can we sign the indictment for you?
Yes, sir.
All right. Where are you going to live when you get out? What's your zip code?
30 is you can Ms. Woods, I'm sorry.
I have a judge.
Address is 3052. Yeah.
You need the zip code.
30. What's the zip code for the house?
30337. I just shared it with
Yeah,
probation, Judge.
that's
All right. Probation already has it.
Because
30337.
yeah, I began to mixed up with my mom address and that address. So
30337 it is, which is Fulton County.
that's College Park.
Okay, so Ms. Simpson's going to give you your probation reporting instructions. Give a listen to her, and then we're done.
Yes, sir. Thank you too, Judge.
You're welcome. You can really thank me and your kids by not ending up back in here again wearing that kind of clothes, okay?
Promise you.
Don't promise, just don't do it.
Promise you. These little days I've been in there, man, it been hard. It's messed with me. Mental, like, it's not no place.
Not a good place to be.
It's not no place for nobody. Promise you. No place for nobody.
So your reporting date on August 14th. So that is next Thursday.
Next
at
Thursday.
8 a.m. And I'll get back with you as soon as we're finished with the address and to get some information.
Yes, ma'am. I got you. And when we get together, I just need the address and all that.
Yes, but Ms. Wood will give it. If she has it, then I can get it.
All right.
All right, that's it.
Yes, sir.
Thank you.
Thank you.
And John Davis should be back there. Then we can turn to the case that was supposed to start at 3:30.
Okay, so it's on her.
I'm not doing Miss Honnold today.
Understood.
What?
Oh, no, I was wondering about, yeah, I was going to do her.
Ms. Honnold?
Yeah.
Yeah, we'll figure out a time next week to do that. That works with Ms. Wood's schedule. So you don't have to play stand-in.
Well, she fired.
Okay, we'll figure it out. Hello?
You didn't seem like you say this.
I didn't.
Was the first year certain?
Yeah, it's all probation. All right, I'll see. I don't know that it's gonna happen. Depends how long Ms. Clark's situation goes. Are you Mr. Davis?
Yes, sir.
Hey, Mr. Davis.
How you doing?
I'm all right. All right, let's go on the record, but let me do this first. Ms. Hardy, we are all set. You are free to go. Thank you so much.
Thank you, Your Honor. Have a good weekend.
You too. All right, so Mr. Davis is on our revocation calendar from yesterday, and I'm sorry you had to sit around all day yesterday as well. It was a monster of a day in here. But we're ready to go forward with your revocation. And I'm gonna see if I can lay my hands on your warrant. A lot of paper. Here it is, John T. Davis. What did we end up doing with Michael Scott? Okay, thank you. Mr. Davis, your case is 22 SC 183787. And in March of last year, I signed a probation warrant that alleges that you were supposed to report in January of last year. You didn't. Then they went to the address of record, knock, knock, knock. Your sister answers and said, John doesn't live here anymore. And then there were phone calls made to the number that you left on file with probation saying, please, Mr. Davis, report to the office, and you never did. It's a long way of saying you did what we call absconded. That they couldn't find you and you weren't letting them know where you were. And we just need to figure out what we're going to do about that. Ms. Simpson, how much time remains on Mr. Davis's probation?
Yesterday's date is 2 years, 9 months, 19 days.
All right, so a little under 3 years left. Ms. Rios, is Mr. Davis admitting to these allegations that he was supposed to report, he didn't, he wasn't at his sister's place, and so he became hard to find?
Yes, Your Honor, he has some reasonings for those. So he's stipulating, but I would like to give those reasonings now.
Yeah.
He said on January 24th, he was told not to report because his PO was in the hospital. And then when it came to them coming to the house, his sister told them that he no longer lived there because she was upset with him because she wanted him to fight her boyfriend, because she got into a fight with her boyfriend, she wanted him to defend her. He was not about to do that.
Good.
So he instead went to a hotel room for the night to avoid trouble. And when they came, it was just bad timing. He has an address now, which is 1379 Elizabeth Avenue. And he can live there with his dad. I've spoken with his dad, and his dad did confirm that he can live there with him. He was working at Corner Tavern as a cook, a line supervisor. He has 10 kids, 1 grandchild. And he has been in continuous custody since April 9, 2024. And then he was released to he was in custody in Clayton County. Then he was released from Clayton County to Fulton County, June 5th, 2025. He said that Clayton, he tried to find out in Clayton several times, but they kept saying Fulton had a cold, but then.
Which we did with this warrant, which went in March of 2024.
Okay, and so he's technically still has been in on this probation revocation. So I'm asking for, to revoke, I mean, I guess total is 14 months. So we can revoke 14 months and then give him.
Remember, I can't give credit for time served.
I revoked 6 months and credit for time served. I think that's how we would have to do it. For him to get, because I guess he wouldn't get credit for any of this 14 months. So, I just revoke 6 months.
Okay. All right. I'll confer with Ms. Simpson. You're basically advocating for a let him out now because he's been in for 14 months.
Yes, sir.
And whatever I would revoke for absconding probably wouldn't be 14 months anyway, and he's done that time.
Yes, sir.
Okay, I follow that. Ms. Davis, your thoughts about what to do in Mr. Davis's case?
Judge, I'm kind of in line with the defense. I mean, if he's been in continuous custody basically since you've signed this warrant, so a couple months later, I do think that's enough time to recognize that you need to report and appear with your probation officer.
Okay. What did you get arrested for in Clayton?
The situation with my sister, when she came to the hotel and I called the police on her just to
This is the sister who wanted you to fight her boyfriend?
Yes.
Okay.
And I called the police on her just to scare her away. And I thought she had left, but she hadn't made the police call. So she got mad and called the police back on me and told them that I jumped on her.
Oh, and so they took her word, arrested you, and lo and behold, you had this warrant.
Yes.
Okay, what were you going to add?
It was actually and that was actually included as a part of the violation.
Oh, it must have been in the petition. Yeah. Oh, and you never did the family violence intervention program.
I actually did the wrong class. I thought I was supposed to do anger management.
That's the easy one.
Yeah, I completed anger management. And then the probation officer came and told me, she was like, you didn't complete. I said, he didn't give me a family violence. She said, no, you supposed to complete a family violence intervention. I said, oh, I completed the wrong class then.
Well, bonus points for you, but you're going to need to do the family violence intervention program.
Yeah, I talked to her. She told me when I talked to Miss Flemister, she said they had resources for it. So when I come in and she'll get the resources I need to do it.
Okay. All right. Anything else, Ms. Rios?
No, Your Honor.
So, Mr. Davis, I do find that you violated your probation. Ms. Simpson, is it your understanding that if I were to revoke him for 6 months, I can do credit for time served? Okay, that's what we're going to do. I just assume revoke you for all the time so that the record shows you need to stick around. But if I do that, you actually have to do more time. I don't think you need to do more time. You've been in for a long time. If you've got 10 kids, which is a whole lot of kids, they probably need you out working at least to help pay for things. If you don't recognize them, at least it's like, hey, I'm taking care of things. And this Elizabeth Street address I've seen in the system, that's where you'll be able to say?
Yes, that's my dad's address.
Okay, all right. So I'm going to revoke 6 months. You'll get credit for time that you did. It'll be a county sentence. And I'm modifying your probation to include the condition that you enroll in the family violence intervention program no later than September 15th, 2025. You got to do it, but not only do you need to do it, you need to start it by September 15th.
I'm gonna start as soon as I get out.
Amen, brother. But you got to do it. And make sure you enroll in the right thing before you sign on the dotted line. Hey, probation, is this the right classes? Because it's several classes.
Yes.
All right. Ms. Davis, anything else?
No, Your Honor.
Ms. Rios? All right. Good luck, Mr. Davis.
Thank you.
Thank you, Judge.
You bet.
But you will sit.
We have nothing going out next week. The short list I'll send out to the lawyers, but it will have that Sampson guy. It may not have Han Hope. We'll see. And then I'll probably pull that case from the Emerson calendar. That is Ms. Wood and Mr. Abadi.
I think his last name is
Davis.
well.
Yep. You have a lot of Davises out here.
I think the Sampson will go away. That's a really old case too.
I think it will too, but we'll call it in. All right.
Judge, do you need me to stick around for anything?
I don't think so, given the hour. I don't, but I will be in contact with you or Ms. Nelson will for when you might be around in an advisory capacity.
Understood, Judge. Thank you. Have a great weekend.
Well, before you go, are you more or less available next week?
I'm available. Mr. Abadi and I will have an update for you probably Monday. Scheduling for a plea probably.
For Mr. Davis?
Yes, Judge.
Okay, excellent. Thanks. Have a great weekend.
You too.
All right, let me get back into this. Mr. Jones and Mr. Johnson, if you want to come on up to defense table, please.
Yeah, we got Cynthia.
Hanhole.
Yeah.
Yeah,
With she got a reset.
yeah, we're gonna bring her back next week to take care of business. Let her know.
Right.
I'm sorry.
Well, we see.
Yeah, good luck delivering the message.
That's fine.
I know, you got it.
Hey, I got
No, no jurors Monday. No. Thank you for asking.
No problem. That was last night. We're going to catch you.
See ya.
Bye. Hope you get to. Thank you.
All right, hey, let's get focused on Mr. Johnson's case. And we don't need to be on the record yet. I think most of what we are going to talk about, I don't know, needs to be on the record. We have a court reporter here virtually, but I just want to talk procedurally first. So, Mr. Johnson, Mr. Jones has filed a few motions on your behalf about getting access to certain information. We're going to talk about that. He also filed the howitzer of his motions, meaning the big one, is what we call a Daubert motion, where he's challenging the reliability of work that was done by the professional who interviewed the alleged victim in this case. We're not able to go forward with that today because that expert could only be available virtually. And Mr. Jones wants that person to be here in person, which is, you're right. It's not the kind of confrontation we typically think of, but there's nothing wrong with Mr. Jones saying, no, we can defer that because I want the expert to be here. So we'll deal with that on a later date. Did you need me? Oh, no, you're good? Okay. So I don't want to miss anything in the catalog, Mr. Jones, but my understanding is you've moved to get psychological records or disclosure of treatment, and then I think you had a subpoena for DFACS records.
Yes, that's correct, Judge. And in addition to the psychological evaluations, any, of course, psychiatric evaluations, any other treatment from mental health professionals.
Okay. And this would all relate to the alleged victim? Not that you aren't petitioning to have your client evaluated, or does the state have some information about your client? It would be about the alleged victim.
No, the alleged victim, as well as potentially her mother and her stepfather, depending on what may be in the defects files. But the defects motion is kind of the superior one. The other ones, depending on what comes out of that, may be subservient to that.
Got it. Okay. So I'll hear from Ms. Clark in just a minute. The way I have historically worked with the DFAX requests is that you actually have the authority to say, Judge, I'd like you to issue an order to DFAX for them to disclose for in-camera review. In other words, I'd look at them. Anything related to the care, custody, and well-being of child X. DFAX then gives to me, they'll give it to me. I'll look through it if there's anything at all, and determine if there's anything that is relevant to these proceedings. If so, you get a chance to come look at them. You don't get copies of them, but you can read them. And that would be the springboard to you then fleshing out the, hey, based on what I saw, let me perfect the motion for psychological reports or this or that, plus anything else that you think needs to be disclosed. That's the fairly traditional approach to it. The other way I've seen it is that the state can get them anyway. And sometimes the state says, oh, we already have them, and I'll let Mr. Jones take a look at them. But I don't impose that requirement on the state. They're not required to do that because they're actually not in the state's span of control, the DFAX records. And sometimes the state don't even think to get them. In a case like this, they might, but other times the defense is really the first to ask for them. And I don't give them to the state. I got them at your request. And so they sit in my chambers, and assuming there's something relevant, and it's not just, oh, the kid was found to be not sufficiently cared for by her mom 8 years before this situation. You don't get that. That's not something that I would be disclosing because I wouldn't see how it fits into the framework of this case. But clearly, if DFAX did some work in connection with these allegations, or there was a prior false allegation of sexual contact or anything like that, those would be things you get to see.
Yeah, that makes sense, Judge. And included in the motion for the DFAX records, it kind of lays out what you're saying. Only I was wanting that as an alternative in terms of the court being allowed to review the DFAX records. I would, in full disclosure, want everything. I understand that, you know, what you're saying is accurate. However, the motion was addressing me wanting to see it just because as his defense attorney, I may be in a position to see things that the court may not think are relevant at the time, just because you haven't had access to the rest of the discovery or had conversations with Mr. Johnson and that type of thing. But,
right. It's an imperfect process, and it may be that you choose to say, I'm going to disclose ex parte some theories of the defense so that, Judge, you're looking with a broader perspective. But I'm not aware of authority that would allow me to hand to you wholesale the DFAX records.
Yeah, I understand just the, 6th Amendment right to confrontation, so I can fully cross-examine witnesses who may have given, previous statements and whatnot. But the court is correct in terms of the law and how Georgia interprets it, and we'd be fine with the court at least getting those records. We just have no access to them right now, despite best efforts.
Well, and there is the corollary that as a trial progresses, I might learn through your presentation and the way you're approaching things with witnesses, these 3 documents that didn't seem relevant now do seem relevant because a witness just said, I've never met a DFAX person in my life, and I know that to be untrue. I need to get you that information. But on its face, it wouldn't be relevant because it's my example of 8 years earlier, there was some discussion about how clean was the house. That's not your client's business. But if someone is saying DFAX has never been in my life until this situation happened, then it becomes impeachment material and it would be disclosed because it has relevance that comes to light only as the trial is proceeding. So I think that's my plan in terms of how we proceed with this, is that based on your motion, I may ask you to submit a proposed order, but if not, maybe that I craft one. I'll reach out to DFAX saying you need to deliver to my chambers any and all records relating to this child, date of birth X. And then we'll let you know when they've arrived, and more importantly, when we've had a chance to go through them. Every once in a while, the file's like that, and it takes a little while to go through, but usually it's not that cumbersome.
And I'd be fine with that. That would cut a lot of time down in terms of what we have before the court today. So if you're going to take that on, there's already a proposed order on the back of the file motion.
Perfect.
Do whatever you want, or I can send you another one. And if the court is gonna take possession of those records and call through them, we can go from there. If something that isn't relevant at first pops up during trial, should we get to that point, then we'd be happy to reapproach and maybe, get documents that are now relevant, et cetera.
Sure. And I should add this as well. The entirety of what is disclosed by DFACS becomes part of the record, be under seal. But should these proceedings end up in an unfavorable outcome for your client, he's found guilty, and there's an appeal, that whole universe is part of the appellate record. So the appellate attorney could say, oh my gosh, McBurney didn't hand over all these things. And then there's error on the court's part. And that's one ground that Mr. Johnson's appellate attorney would be able to raise.
Understood. That's in the motion as well.
Good.
We want everything to be included for the record,
Thorough as I expected. Okay. So if we do that, should we table for now then what I'm calling sort of the Bobo motion?
Well, we still have the psychological records, but I think the court is basically, I don't want to put words in your mouth, saying, let's see what's in defects, and then if there are psychiatrists and psychologists who have treated, the alleged victim along with these witnesses that are mentioned, then we can come back and address that as well.
We can. You're certainly not waiving anything now. Another way we can tackle the psychological and psychiatric records is have Ms. Clark confer with the alleged victim and that family, and they may say there's nothing out there because there's never been any counseling or treatment or whatnot. I can't make the state produce something that doesn't exist. And that is another way to answer that. But you may have a reason to know that there has been that kind of treatment. One way to know is because it would be in the DFACS records. But short of that, if the DFACS records don't exist or they don't give you any reason to believe that there were psychiatric or psychological treatments for either the alleged victim or her parents, and you'd have to help me understand the parent part when we have that debate, then we find out from the state whether there's something that is even subject to disclosure. But do you know? I mean, do you have a reason to believe, or you're just being thorough and don't want to leave that stone unturned?
More so thorough. However, in discovery, obviously there was a forensic interview, and they make mention of other treatment. They don't give doctors or psychologists names, but there's mention that somebody besides the forensic interviewer was doing counseling, therapy, etc. We just don't know yet, but the way the court is structuring this hearing, it gives me confidence that should that be an issue, we haven't waived anything and names pop up, or if I can get new information, I can bring that back to the court and we can address this during the docket portion as well.
100%. We can do that.
I'm satisfied.
You're good? Ms. Clark, how about you? Maybe you can clear all this up. There are no DFACS records and they've never seen a psychiatrist in their lives.
I know Fulton County DFACS does not have any of the records. But the other county, he references another county, Muskogee, I think. Muskogee,
Yeah,
sorry.
Georgia.
I'll need some time to get access to those. My response to Mr. Jones, when he asked about the records, I told him that.
Which records? DFACS or the psychiatric records?
DFACS records, psychological records. I told him that the only records that the state would be able to provide him is what's in discovery. I wanted to point, I don't know if counsel has seen it, but if you look in the discovery that's been already served to you, Your Honor, there is a therapist. Her name is Tori Massey Young. She has actually provided her notes from the interactions with the victim in this case. So there are several different sessions that are referenced and that are discussed.
So you've disclosed that insofar as that's one component of treatment that, what are we referring to? Are we referring to the alleged victim by initials or?
Well, her name is Abigail, so.
Okay, Abigail. So Abigail did receive some treatment from this person, and whatever that treatment consisted of, the notes have been provided.
Well, I do still need to meet with the guardian to determine if there was additional, But because of the fact that there were actually therapist notes provided in discovery,
Yeah.
I didn't feel that the state, we didn't have anything else in our possession. I'm opposed to anything that is definitely an in-camera review. Have no problem with that. I told Mr. Jones that prior to him even filing this motion. But it is the state's position that that defense does not have the right to access the psychological records of the child if they're not relevant, which you will make sure of that.
I think everyone agrees with that. And so there just needs to be that filter that occurs. So I will reach out to DFAC Central and say anything and everything relating to Abigail in your files, whether it's Muskogee or Fulton or Pickens or Walker, they need to get that to me. And then I'll let Mr. Jones know there's nothing, or I did receive something, let me look through it. And then based on my review, you should come on by because there's some things you're going to want to read. I'm going to rely on you, Ms. Clark, to speak with the guardian to find out what is the universe of treatment that Abigail has received. And then you don't need to disclose things other than she's seen these 4 people, whatever it is, and for what. And there may be some we exclude because she saw someone when she was 2 because she had nightmares about witches. And Mr. Jones may be able to connect the dots, but assuming he says, no, that really doesn't have anything to do with this case, then we don't need to worry about that treatment provider. But if there are 1 or more individuals with whom Abigail met after this alleged incident, then we're going to need to work through what is step 1, disclose to me so that I can look at it to say, I believe there are things that should go to the defense. Nothing would be disclosed without a hearing. When it comes to those medical records. I'm gonna call them medical records for short, but I appreciate it's not a broken arm. It's I'm having thoughts about this or that. The defects piece, I control the medical part. There needs to be a hearing where you can be heard as well. All right, thank you. That's nice handwriting. So if you can do that and figure out the universe of providers, if there's more than that name you mentioned, that's something I think we can circulate via email. We don't have to have a hearing yet. I'll work on getting the defects records, and then we certainly need to set this down for the 702 hearing in connection with the forensic interview. Mr. Jones, anything else on behalf of Mr. Johnson?
I think that gets it for the most part. I think my client would like me to let the court know that we're aware of Tory Massey Young, but I would consider those more so summaries instead of like detailed notes, not what we're wanting to get at in terms of the reports and counseling sessions and more detailed things instead of, alleged victim said this happened on that day. And that's kind of what, and we were discussing, that. It's very general, very, very much a summary, but I think we got everything covered from what I've heard. Okay,
well, let's leave that one open. And it may be that what has to happen is that the entirety of the file that treatment professional has in connection with Abigail, I need to get, and I can look at the summaries and say, you know what, you got what you're going to get. There's not more to it than that, than things that you wouldn't be entitled to get, whatever my filter is. Or it may be, you're right, look, here's some more pages that need to come across. Before I would disclose anything more, like I said, we'd have a hearing, make sure you meet the BOBO standards and the state has a chance to be heard. But I'm hearing you say, we may not have checked the box on that treatment professional. But I think Ms. Clark acknowledged that because she needs to confirm, do those summaries cover all the sessions that happen? Because if they don't, you for sure don't have everything you're entitled to because you don't have summaries from other sessions. Okay?
Fair enough, Judge. Thank you.
You bet. What this means is our current schedule is off. Mr. Johnson was set for a final plea hearing on September 5. I don't know that we'll get through all this before the final plea. I might say, but we could get through it before the trial date and just preserve his final plea rights, but we'll see. I don't know how hard and fast we can hew to that late September trial date. Anything else, Mr. Jones, on behalf of your client?
No, not on behalf of Mr. Johnson.
All right, Ms. Clark, anything else?
Just only that we'll, once the court decides on a date for the 702 hearing, I'll have to coordinate flight arrangements from Hawaii for the forensic interviewer.
Well, I think what we'll do is actually reach out to the two of you, Jones and Clark, to say, here are some dates and windows, what works the best. You'll consult with our Hawaiian, you'll consult with your schedule, and we'll figure out which works best. Because I'm loath to say, here's a window I found, and then it turns out that she can't come from Hawaii that day, or there's a better day to do it.
Yes.
Okay. Hawaii. All right, I think that's it. Thank you, everyone.
Thank you, Your Honor.
Have a good weekend.
You too. Ms. Rivers, thank you so much.
Okay, Judge, have a good weekend.
All right, see you around.